Good morning. Good morning, my friends. Good morning. Thank you so much for coming to spend part of well, I think will be all of your Wednesday, July 24th with me. You're here for day 2 of the Ashley Benefield trial out of Manatee County, Florida. And I think it's a lot different. This trial is turning out to be a lot different than a lot of people thought. And it's a lot different than the picture that was painted in the media so far for me. What say you? I'd made the mistake yesterday of going over and checking out some other coverage on some other channels that you may be familiar with. I gotta say, I was kind of horrified by what I saw over there in the chats. And I just find that we are very lucky here to have the amazing moderators that we have and the amazing community that we have because uh, the hatred that is out there is it's really beyond. I'm kind of flabbergasted by it. I've only been doing this YouTube thing for about a year, and I didn't realize how much hatred and vitriol there is out there. How the American philosophy, constitutional right, let's say, of innocent until proven guilty has sort of disappeared. And how people are so eager to paint a picture of a person being guilty before they even have one day in court. And I'm seeing it even more in this case, I think, because Ashley Benefield has never given a statement after September 20th of 2020. She's never given a statement to the media. She's never testified at any hearings involving this case, and no one's ever heard from her. And so I don't know if that's the reason, but it's really disappointing to see. Disheartening, disappointing, sad, maybe, because I know how many of you in this chat and on this channel and in the comments have told us your stories. And my heart breaks for you, but you are warriors. You're warriors, men and women both. And you've been through it, and you can see the signs of coercive control, of DV. And it needs to be talked about more because I guess a whole lot of people out there don't understand it. And I guess if they don't understand it, they're pretty lucky, right? Somebody said that the other day in the comments. They said, listen, if you don't know what this is like and you've never been through it, then consider yourself lucky. So we don't play that game here, right, homies? We don't play that game here. Hi, Sylvia. Hi, Sylvia. It's because people love to be part of a group and social media feeds witch hunt mentality, bullies. Why, though? Why can't there be like a community of really nice people? That's what we're doing here. That's what we're trying to do here. Here's the daily reminder. Be nice or leave. If you're going to spew hatred in the chat, my mods aren't going to tolerate it. I probably won't even see it because the chat here flies by so quickly, but they're not going to tolerate it. Yes, Pilgrim Shadow. Thanks a lot to the mods for utilizing boarding passes. I said that yesterday. I said to one of the viewers who was spewing vitriol, I said, this is not an airport. You don't need to announce your departure. Just go. Just go. Feel free to move about the cabin, my friends. Good morning, Michelle from the UK. Glad to be spending the afternoon and evening with you guys. I've been watching from afar, but wanted to subscribe to this wonderful community. Thank you, Michelle. Everyone say hi to Michelle. Hi, Michelle. Welcome. Tommy, this is what I'm saying, right? If some jurors can find Karen Read guilty of something, the world is screwed. Physics show Officer John O'Keefe was not hit by a car. How much louder do we have to say it for the people in the back? I don't know what's going on. But again, same thing with Karen Read. Karen Read, though, made some statements post-death of John O'Keefe. And so people were criticizing her for that, right? People were criticizing her, I mean, for just about anything they could think of. Her facial expressions, what she wore to court, the statements that she gave. I think she did a Nightline interview of 48 hours, something like that. And so they had all of that sort of what they consider to be ammunition. But in this case, it's cousin Tommy out there spewing a whole narrative. Not you, Tommy. The other Tommy who spells his name with I-E. First of all, Who spells Tommy with IE? Does anybody know a Tommy with IE at the end of it? Second of all, cousin Tommy has been out there as the family spokesperson, spewing a narrative for close to 4 years. And if you weren't here yesterday, go back and watch the testimony. Go back and watch cousin Tommy on the stand, because cousin Tommy, it came out, seemed to have a thing for Ashley. And even after Ashley filed her order of protection against Tommy's cousin, Ashley's estranged husband, Doug, Tommy was trying to, I don't know, get with Ashley. He was on Ashley's side, and something must have happened. Sort of like a Higgins, let's say. Let's say Ashley ghosted Tommy. Then Tommy's changed. And boy, when he was presented with those text messages on the stand yesterday, he did not want any part of it, did he? Some people were saying that he got married after this, and his wife was 30 years younger than he was as well. And not that there's anything wrong with that, but that he may not have wanted to admit what was in those text messages because perhaps he was dating his wife at the time. Tommy was disgraced yesterday, Lisa, right? Lizzie, sorry, Lizzie. And so many people out there were commenting in the comments last night. And listen, the block button is my best friend. That's what I love about YouTube. You can block people, you can delete them. Can't do that out there on the cesspool of Twitter. People can say whatever they want about you. But in this community, I get to pick who's in this community. And I get to pick the comments that I delete. And my moderators are on top of it. And the people that get timed out in the chat for being nasty and attacking each other. So people are like, "What about freedom of speech?" Well, I don't know. It's my community, right? If I don't tolerate hatred, I don't tolerate hatred, and that's that. Thank you, Dickless Tracy, for thanking me and for being a member for 2 months and for your email. And thank you so much for being a class act. And I guess if you know, you know. Oh, look at this. Amontillado Yato. Tommy immediately appeared on Court TV. I'm not surprised. Did he last night? Or you mean right as soon as this as soon as his cousin died? Tell me, Amonti, because I did not watch any Court TV last night. I just can't anymore. But that's interesting. I can't believe that he was going to Court TV last night after his debacle, his Michigas mess on the stand. I have Court TV up, but so far they don't have their camera up yet. What time is it? 8:58. Why wouldn't they have their camera up? All right. Law and Crime has their camera up, so I have the volume on, and I'll put it up as soon as they put their volume on. Good morning. Amy says, "Thank you, Melanie, for being a real woman. There's a worldwide epidemic of violence against women, yet there are no victims and survivors who believe us." And that's the thing, Amy. That's the problem. That's why so many women are like, "What am I going to do? Why am I going to call the police? Nobody's going to believe me. He's got the money. They're going to kick me out of the house." So many of you told me your stories about how you did. You tried to report it to law enforcement, and then you wound up getting kicked out of the house with your children because he was the breadwinner. I'm horrified. Amonti, he told Vinny that he was not amused how the defense treated him. Oh, that's interesting. I can't believe that he went on Court TV. Isn't he subject to recall? Isn't he still under subpoena? Couldn't they call him again? Anything he's done on Court TV now can be used against him. It's a public statement. So that's really interesting. Hello, Jill. I hope you got my thanks. Was it email? Jill, I get so many emails that I rarely have a chance to go through them daily, but thank you for thanking me. Be back at 4:30 UK time. Get ready for questions and updates. You got it. You got it. Thanks for tuning in. We have a lot of viewers from across the pond and from Ireland. Hello, here's Michelle from Ireland. Missed yesterday, but caught up this morning. So you're all ready for day 2. You caught up on you watched all the testimony, Michelle, this morning? Well, I guess what time is it there? Are you 5 hours ahead or 6 ahead? It's 9 a.m. here. Right, here comes Ashley and her team into court. So you had a full day, Michelle. How's your weather in Ireland? I've never been. I want to go. Obviously, I'm Irish, so I'd like to go see where my people are from. All the people in Ireland are so friendly, and it's beautiful. And I want to see some castles, and I want to visit the countryside, play some golf. What's the best time of year to go to Ireland, weather-wise? Hello, this is in Sydney. We have some down under. No, I have not, Phoebe. Are they going after Aussie now? No, I don't know where they're doing that, but I do not participate on the cesspool of Twitter. I don't know if that's where that's happening, but why would anybody want to subject themselves to a platform that has zero regulation and 100% tolerance for vitriol, bullying, defamation, and cruelty? Not me. Not me. It's not my scene. That's devastating and horrible. And it's usually mostly always the women that they seem to go after, right? Why is that? Good afternoon to South Africa. Hello, Cheryl. It's 3 o'clock in the afternoon in South Africa. She says, let's see what looks better. I'm going to switch to Core TV because they seem to be better with people sharing their streams. So we don't like to get stricken. Although I don't know. I don't know if Law and Crime is doing that anymore, but they used to. And you can let me know if their volume is terrible, in which case we will switch back. Aim to please. Lulu says, I only went back on X to expose the abuse. Unsuccessful still. See, Lulu, what's the point? Oh, Beck, I'm not surprised, but I'm not going to even mention that person's name. But thank you, Beck Edwards, for telling me that. I'm going to delete it because I don't even. It's kind of like if you don't give these people air, maybe they will just die like the trolls that they are. They'll go away. Yes, Jill. Remember the Western women comment yesterday? OMG, that was beyond. We don't play that over here. And if people want to spew stuff like that, I'm going to pull it up and call them out on it because we don't do it. Oh, good morning, Michelle's. Michelle's didn't do any background, so she's coming in as the jury. Good. Mistrial, like your name, stand your ground defense statistically works way better for white men than women or POC. Did you see the verdict? That's Eva Benefield. That is Doug's sister. I'm sorry, Doug's daughter. She's now 23. She was 15 when Doug secretly married Ashley. We can watch this, the verdict later, but give me a second because somebody sent it to me. There was a woman who was acquitted in Florida, in Palm Beach County. I think it was Monday or Friday. All the days start to blend together after a while, don't they? For me too. It was Nosy Rosie that sent this to me. Marsha Thompson, Florida versus Marsha Thompson. I have the full verdict here, and I didn't watch the whole trial, so I didn't see all of the testimony, but so many of you did. Did anybody of you follow that trial? The Marsha Thompson trial out of Palm Beach? She too was a battered spouse for at least 10 years physically and more than 20 years emotionally. Julie says, Ireland is lovely, but you'll need to visit Wales too in the summer. Oh, good morning, Denver. I don't know your mom. I don't know if you know this, but I'm a buff. Sco Buffs, proud alum, University of Colorado, Boulder. Sco Buffs. Some of the most fun years of my life were spent in Boulder, so I have a big connection to Colorado. Love it, love it, love it. Hoping to get out there this year for a game or two. Very excited. Yeah, I don't find the Pac-12 network anymore. So good morning to Denver and all of Colorado. Jury is entering. God save the Commonwealth. It's a reference from the Karen Reed trial. Sound good? Alicia Byers is Ashley's mom.
All right, y'all can have a seat. Good morning, everybody. Welcome back.
Those of you who don't know,
Check and make sure we got the right notes in the right place. Those are yours. Check
sound
them
is way
again,
better.
make
All
sure
righty.
you still got plenty of ink. All right. Good morning, everyone. Just want to make sure that nobody began discussing the case amongst yourselves or started deliberations. Nobody discussed the case last night or this morning with anybody outside of the jury. Nobody approached you or talked with you or tried to influence you in any way, and you didn't do any research on the people, places, things, or legal topics we've heard anything about. All right, everybody said.
We're going to switch over to Law and Crime because Court TV is a little bit behind on Law and Crime. Ashley's mom has already taken a seat.
You
There we go.
reach about 12 to 15 inches from that microphone. It does adjust up, down, left, right as you need it. If you speak in a loud, clear voice right into it, it'll pick up everything.
Thank you.
Yes, ma'am.
Good morning. Please state your name.
Alicia Byers,
Can you spell your first name and last name, please?
ALICIABYERS.
And your relationship to Ashley Benefield.
She's my daughter.
And when did she start living with you in Florida?
I can't clearly remember.
Okay. Was there a time when Ashley moved in with you when she was pregnant?
Yes,
Okay. And she was married at the time, but it was just Ashley that moved in.
yeah, he brought her down.
Okay.
And yes, and yeah,
And she moved in with you.
yeah. He told me I needed to take care of her. He dropped her off.
Okay. So
He told me I needed to take care of her. He delivered to her mother. Listen carefully for those of you that have been following this pretrial and all the things that you've been told. He dropped her off, said you need to take care of her.
stayed with you from that time on, correct?
Yes,
Okay. And does Ashley have a concealed weapons permit?
yes.
Does she own firearms?
She doesn't now, no.
Did she own firearms then?
Yes.
Okay. How many?
2, I think. Yeah, 2.
Did she ever go to the firing range or anything?
Yes,
I'm sorry.
yes.
Okay. How frequently would she go?
Well, we did all the courses to get the concealed carry, and I don't remember.
Okay. And very shortly before the shooting, she went to the shooting range with your neighbor, correct, John Fantz?
I don't think that was close to that time, no.
So it may not have been close in time, but they have gone together? Ashley and John Sands.
I'm not sure.
Okay.
I don't know.
Okay.
Hey, her mom's not testifying against her. She was subpoenaed by the prosecution to testify. I don't know how they think that her mom's going to be helpful to their case. She had a concealed carry permit. She went to the firing range, so she knew how to use a gun properly. Goes to what we were listening to yesterday, the testimony where there was a jam in the gun. It could have been because she was holding the weapon loosely. She knew how to fire a gun. She had a concealed carry permit. When Doug met Ashley at the home of Dr. Ben Carson in the summer of 2016, she was carrying a firearm in her bra. She's no stranger to firearms.
And you and your daughter obviously are very close. You lived together, just the two of you, right, for a while.
Mhm.
And then once the baby was born, the baby lived there with you.
Correct.
Correct. Okay. And around that time of the shooting, were you planning to move to Maryland?
Yes.
And you had a house that you inherited in Maryland?
It was the house I grew up in.
Okay. And you inherited that house?
Yes.
So your plan was to move to Maryland with Ashley and Emerson, the baby?
Mhm.
Okay. And Doug, Ashley's husband, was also moving to Maryland?
He was moving somewhere else. He was,
Okay.
he had found his dream job.
So he was moving to Maryland, but not moving into your same house?
Correct.
Okay. And he was packing up to move at the same time you were?
I assume so, yeah.
But he was coming over to help
Yes.
you move?
Yes.
And on a regular basis, almost every day, he was at your house?
Maybe the last week.
Okay.
Yes.
Helping move boxes and things like that?
Yes.
And you all rented a U-Haul, right?
Somebody rented a U-Haul. I don't know who.
It was in your driveway though, correct?
No, it was not my driveway.
The day the shooting happened, was it in your driveway?
It, I think
If you don't know,
the
that's
U-Haul
okay.
was getting there when I was leaving.
Okay.
Yeah.
But you also had a pod, one of
Correct.
those
That was in my driveway.
in your
Yes.
driveway. Okay. On the date of the shooting, what time did Doug get to your house? Do you remember?
No, I mean, it was, I can guess, maybe like 5 or
Don't
something.
guess.
I don't know.
So it was still light out?
Oh, yeah.
And maybe in the afternoon sometime?
Yeah, I don't clearly know.
Okay. So when he showed up, what did you do? Did you stay there or leave?
I was leaving when he pulled up.
And where did you go?
We went to the park.
Okay. And when you say we, who is we?
Oh, Emerson and I.
Okay.
Yes.
So just you and Emerson. And
Yeah.
how old was she at the time?
So I guess 2, maybe. Yeah.
Approximately.
I'm kind of wishing that they didn't name the daughter. She's like 6 now. Do they need to name her?
Yeah.
And at the house, was it just Doug and Ashley then
Yes.
when you left?
Mhm.
And you've obviously been in contact with your daughter almost every day since the shooting, correct?
Leading. No, I will roll.
You've been in contact with her basically every day, correct? Since
Not initially, no.
For the last several years, you've been in contact with her every day.
Well, yeah.
Okay.
I
And
don't know how to, okay, yeah.
did she ever, during any of these conversations, tell you what happened when she had to shoot Doug?
Never. Nope.
When you came back from the park, I'm assuming she was already in the squad car or she was already with law enforcement?
Why are
I
you
had no idea
assuming?
where she was.
I'll sustain.
Okay.
Okay. They're calling Ashley's mom as a witness in their case in chief, which I find to be very strange. I don't know how they think this is going to be helpful to them. So when you call, even if it's an adverse witness, someone, you cannot ask leading questions. And she's asking leading questions. Not you've been in contact with her every day since then. The question is, how often are you in contact with her? You can't lead your witness just because perhaps this witness is not going to be friendly to you, in your opinion. And this prosecutor should know better. But I'm glad the judge isn't having any of it.
So at the time that the shooting happened, she didn't tell you what happened,
No,
correct?
we've never talked about it.
And to this day, you've never talked about it.
No,
Thank you. No further questions.
Why did she call her?
Good morning, Ms. Byers.
morning.
Are you nervous?
Yes, very.
Scared?
Yeah.
All right, let's try to relax. If my questions aren't clear, please just ask me to repeat it.
Okay.
Was there ever a time when you and Ashley resided here in Bradenton, in the home, that Doug lived in that house?
Never.
Would it be safe to assume, and perhaps you can enlighten us a little bit, how was your relationship with your granddaughter, Emerson?
Oh, very good. Yes,
Okay.
we're very close.
And would you try to spend time with her?
Yes,
Would that include you taking her somewhere on a regular type basis?
yeah,
Would that be to the park?
yes.
And tell the ladies and gentlemen of the jury, Ms. Byers, how often you engaged in that practice of you and Emerson going to the park?
Usually several times a week. And we'd go after it cooled down because the park does not have very good, tree coverage. So it was very hot. That was the only comfortable time to go.
So we think trying to avoid the heat or
Oh, yeah.
minimize it, it'd be later in the afternoon,
Yeah, it was brutal out there otherwise.
Yeah.
Florida,
almost as bad as it is now.
Right, exactly.
How far away was the park?
It's a short walk. I mean, we'd always walk over there. So I don't know, it'd take us maybe 5 minutes to get there.
Okay.
So
And on this particular day, I think you told Miss O'Donnell, if I'm not mistaken, you were actually in the process of going with Emerson to the park when Doug arrived?
yes, we're walking down the driveway and I had her in the stroller.
Hello, Beck Edwards. Good morning. The lawyer's name, defense attorney's name is Neil Taylor. Neil Taylor. And if you've been watching some of the pretrial coverage on this from some of the mainstream media court channels, you may have heard people saying Ashley sent her mother to the park so that she could kill her husband. Tell me if you think her mom is being authentic, if you think her mom is credible. Doug never lived with them in Florida. That's another thing that has been spun pre-trial.
And on this particular occasion, there was nothing unusual about you going to the park, just
Oh,
like
no.
you
No,
did
that's
regularly.
Yes.
Give me a moment, Your Honor, please.
I agree, Dave Elliott. He does have some golden pipes, doesn't he? He could totally do voiceover. Could you see him doing commercials like Morgan Freeman or... I like his voice. When I was in watching some other shots yesterday after the fact, I was surprised at the comments
I believe that's all I have.
people had
Thank you,
about
Ms.
Can you redirect?
him.
No.
Oh, hold on, man, don't get up yet. No redirect.
No.
Can this witness be released?
Yes.
Yes.
Ma'am, you are released from your subpoena. The rule of sequestration had been invoked, but you're now released from your obligation.
Okay. All right. Thank
There
you.
you go. Thank you.
Judge, I apologize. In consulting with counsel, I do think I want to leave her under subpoena for,
All right,
sorry.
Ms. Byers.
Keep
So
her
what
under
does that
subpoena.
I'm going to explain that.
Okay.
All right, so what that means is you remain under subpoena and subject to being recalled at the trial.
Okay.
The attorneys at the beginning of the case invoke what we call the rule of sequestration. So the instructions I'm going to give you are similar to what you've already probably been told by the attorneys. You're not to discuss your testimony here in court, the questions asked of you with anyone else, including the attorneys. You can't talk with other witnesses about what their testimony was or the questions they were asked. And it's my understanding this may be online. You are prohibited from watching anything that's going on within these four walls, ma'am, until you're released from your subpoena or until the jury comes back and the verdict is released. Okay? All right, thank you, ma'am. You're free to go for now.
That's interesting. I mean, are they going to call her back on? They're going to call her back on their rebuttal case? She did nothing to help them. I don't even understand the purpose of her testimony. She told us that Doug never lived in the house with them, that she went to the park with the daughter several times a week after it got cooler out at night. That Doug was not going to live with them in Maryland, which is something else that's been spun out there pre-trial, that they were going to move in together, which they were not.
Thank you so much.
Good morning, ma'am.
Good morning.
My name is John.
All right. In the interest of not being stricken, as someone pointed out to me again, we may try to go over to Court TV because they're a little bit behind anyway. And as you know, we tend to get a little bit behind as well. So give me a second. This is Dr. Barbara Russell.
And who all lived at the house?
Myself, my husband. Correct.
All right.
Nice court
My name is
officer
Judge
pulling
Wright.
out her
I'm
chair.
presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches away from the microphone. It does adjust up, down, left, right, however you need it. But if you just speak directly and a loud, clear voice into the microphone, it'll pick up everything.
Thank you, sir.
And please state your name.
Barbara J. Russell.
Can you spell Barbara Ann Russell?
BARBARARUSSELL.
And what is your profession?
I'm a licensed clinical social worker. I have a doctorate in clinical psychology, and I work as a clinical and forensic mental health professional.
And how long have you known Ashley Benefield?
I've known her since April of 2020.
And when you first became involved with Ashley, it was on a professional level, correct?
Correct.
All right. And then since the time that you had that interaction, you have stayed in touch with Ashley.
Correct.
And subsequent to the shooting that happened, she actually moved into your house, correct?
Correct.
And who all lived at the house?
Myself, my husband, and my 19-year-old daughter.
And approximately how long did she live at your house?
Approximately 8 months.
And you would see her on a daily basis?
Pretty much, yes.
Okay. Did she, when you first spoke, when did you first see her or speak to her after the shooting?
About 1 o'clock the following morning.
Okay, so this happened in the evening time, so it would have been 1 o'clock the next morning. And at that time, did she say to you, "Oh my God, he came after me, I had to shoot him"? Did she say that?
She didn't discuss what had happened at all, nor did I ask.
Okay. And
tell me, those of you in the chat, I know there are a lot of survivors out there in the chat. Did you often talk about what happened with strangers? It's interesting. She moved in with her therapist for 8 months. Yeah, that's weird. How is that a thing? Right. And how long is she supposed to put up with it? Right. And is it shocking to you that she never would discuss it with her mother? It's not shocking to me.
to this day, are you still in contact with her?
Not that one. I'll overrule on that question.
To this day, are you still in contact with her?
Yes.
And to this day, has she ever told you what prompted her shooting, Doug Benefield?
She never gave any kind of narrative of what prompted the shooting. My understanding is that
Don't-
I
she was
just want to know if
defending
she
her life.
told you. I just want to know what she told you. She did not tell you anything.
Did you hear what she said? She snuck it in there. She didn't tell me. My understanding is that she was defending her life. I'm going to take that back for you. Again, why does the prosecution call witnesses that they have no control over, that they have no idea what they're going to say? I I don't think it's smart, but it's not my case. So listen to the answer.
To this day, are you still in contact with her?
Yes.
And to this day, has she ever told you what prompted her shooting, Doug Benefield?
She never gave any kind of narrative of what prompted the shooting. My understanding is that
I
she was
just want to know if
defending her
she
life.
told you. I just want to know what she told you. She did not tell you anything, correct?
She never gave me any narrative about what had happened.
Thank you. No further questions.
Okay,
Problem,
what?
sir.
Good morning, Dr. Russell. I have a question from your own personal knowledge. You're aware that Ashley's lawyers instructed her not to discuss the facts, correct?
Of course, any good lawyer would do that.
That's right. That's right. That's right, Barb.
Give me just a moment, Your Honor.
Of course, yes, sir.
Did there come a time, Dr. Russell, when a detective, Warren, contacted you about the case?
Yes.
Did you have discussions with Detective Warren?
I met with him once, yes, for about 90 minutes.
And in that meeting, did you relate to him that,
Objection, hearsay.
I'm asking a question to this witness.
Well, I understand, but if it calls for hearsay, once you approach, so I can hear what the question is going to be.
It's not hearsay if she told it to him. It's her statement. But okay, the judge is so personable. Yes, defense can object to the leading, and they have been. Cher, good morning. He is undercutting any consciousness of guilt argument. Exactly. Cleric, thank you.
When you spoke to Detective Warren, Justin, you identified yourself.
Correct.
This was a face-to-face conversation.
Yes.
If you were to tell us today in court about the discussion you had with Detective Justin, would it be any different than what you told Detective Justin on that day?
No, of course not.
You have an opinion, do you not?
Objection.
Rephrase. As you sit here today, do you have a conclusion?
Objection.
Sustained.
All right, give me a moment.
He's trying to get in that she thought that Ashley was in fear for her life. He's going to have a hard time doing it because she's not being offered as an expert witness. She's being offered as a fact witness, so she can't testify about her opinions. I was kind of wondering why, if she was Ashley's therapist, she would be called to the stand because she's not. I mean, there's patient therapist privilege, so she couldn't testify about anything that happened in their sessions. We're a little bit behind.
That you had an opportunity that morning, from what you had to say at approximately 1 o'clock, technically the next day, to observe Miss Benefield, correct?
Yes.
I'm going to pass you a picture that's previously been marked as State's Exhibit number 21, picture of Ashley Benefield that was taken on the day of the incident.
Yes.
May I approach you on it?
Yes.
Does that picture reflect any swelling to Ashley Benefield?
Objection, as interpreting the picture.
Sustained.
Did Ashley Benefield look like that when you saw her prior to the day of the homicide?
Prior to the day, no.
Okay. What was different about her?
When I saw her after the incident, there was edema, swelling on the side of her face.
Okay, and did that include her right eye,
It included her left eye.
left eye rather?
Yes.
Okay. And when you saw her before the homicide, did she have swelling on the left side of her face, on her cheek and her eyelid?
She never had, no.
In fact, when you saw her immediately following the incident that morning at about 1 a.m., was there any indication that by Ashley that her head was hurting?
Objection, hearsay.
Sustained.
Spontaneous statement, Your Honor.
That existing mental, emotional, physical condition.
Can we approve?
Yes.
There are some exceptions to the hearsay rule that could apply. But she is testifying she saw Ashley at 1 a.m. that same evening, and she did notice swelling to the left side of her face and her left eye. I don't know why the prosecution called this witness. Oh, look at us on real time. Yay, us. Phoebe Mix says, to me, this looks like the prosecution didn't find witnesses to go against Ashley. That is no one who knows her. Maybe.
Did Ms. Benefield that morning give you any indication that she was in pain?
Yes,
And did you refer to any particular area?
yes,
What?
her head.
Thank you.
Redirect.
No.
Sarah in shock and horror.
Can this witness be released?
Yes. Oh, I'm sorry, no. She is to remain under subpoena. She can be released at this time today.
Ma'am, the rule of sequestration has been invoked by the attorneys, so that means that until you're released from your.
Yeah, so she can't sit in the courtroom as a sign of support for Ashley. They must be friends. She must have been her therapist first, and then they became friends. I'm imagining, and that's why she moved in with her. But a hostile witness is somebody who becomes a combative on the stand, at which point you can ask for permission to lead because as a hostile witness. So that this would not qualify. She was not combative. She was answering the questions.
Judge, the state called Lieutenant Dan Dickerman. I know he was caught in the line, so I just.
He was caught in the security line. People are also questioning about Eva Benefield being allowed back in the courtroom. Yesterday, the judge did say that she would not be allowed to sit in the courtroom because she was still under subpoena. However, under Marcy's law, which is spelled Marsy, in Florida, the family of victims have certain rights. And so the prosecution argued that she should be allowed to sit in the courtroom under Marcy's law, and the defense didn't object. So that is why we saw her back in the courtroom. We didn't hear that sidebar, and so it was confusing to us yesterday when we heard the judge tell Eva that she could not stay in the courtroom, and then we saw her sitting there. So that is the reason for that. Genia, what have the prosecution got from the last two witnesses? I found them both to be credible and on Ashley's side. And the last witness, in fact, showed that she saw injuries to Ashley when she came home at 1 a.m. and that she was complaining of pain to her head.
So, Mr. Affirm,
Hello, sir.
Yes, sir.
My name is Judge Ryder, presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, right, however you need it. Just speak in a loud, clear voice, we should hear everything.
Yes, sir.
Did Judge Canoni ever introduce herself to any of the witnesses that came to the stand? Did you hear what he said? Hello, my name is Judge White. I'm presiding over this case. Make yourself comfortable. I don't remember Judge Canoni in the Karen Reed case ever introducing herself to the witnesses.
Good morning.
Good morning.
Please state your name and spell your last name.
Daniel Dickerman, Dickerman.
Where do you work?
Of the Manatee County Sheriff's Office
How long have you worked there?
for almost 29 years.
What is your current position?
I'm a lieutenant in road patrol.
And what was your position back in 2020?
I was the senior homicide investigator assigned to the Manatee Homicide Investigative Unit.
Okay, so Manatee County, say that again?
Manatee Homicide Investigative Unit, MHIU.
MHIU. Okay,
Yes.
so you were the senior investigator in that unit.
Yes.
And if you could just explain a little bit, what is that unit?
So that unit is a group of detectives formulated from all the agencies within the county, the Sheriff's Office, Braden Police Department, Palmetto Police Department, and all 3 beach agencies. We all respond out to all homicides that occur within the county, regardless of city jurisdiction, everything, so we can all work together and investigate that and determine if any criminality is a result of that homicide will need to come forward.
And just discuss a little bit how you work as a unit, and is that different than how a detective may work in a different part of the sheriff's office?
Yes, in the sheriff's office, most cases are assigned to a single detective. They go out, they do all the work, they write the report, they bring everything together in a normal, a smaller case. In these cases, we determine what we call a lead detective. That lead detective then becomes, for all intents and purposes, the supervisor of the case. He makes assignments. We go out, all the other detectives, we do our respective assignments, we report back. The lead detective becomes a basic gathering point and a keeper of all the information to make sure the flow goes smoothly to one location and we're not duplicating efforts or stepping over each other's toes. And then he makes the ultimate decision once he has all the information.
Okay. And are you,
Kind of like Michael Proctor was supposed to be the lead investigator in the investigation of the murder of Officer John O'Keefe, except then they demoted him during the trial to something like case manager. I think the MSP and Canton PD need to take a lesson from the Manatee County Sheriff's Office because they understand about procedure, and it seems to me like they understand about chain of evidence, chain of custody, proper handling of evidence, proper investigations, crime scene tape, swabbing, bagging clothing properly. It's like night and day, these 2 trials.
as a unit, a part of any decision-making that happens within the unit or that happens in a case?
Yeah, we have meetings on every case
Okay.
to discuss the comings and goings and the happenings of the different case.
And so did you work in this unit, the MHIU, at the time that the shooting occurred?
I did.
On the date of the shooting, were you notified of the shooting?
I was.
Okay. And about what time was that
It
approximately?
was between 7:30 and 8 p.m.
Did you go to the scene?
I did.
And when I say the scene, where the shooting happened.
Yes, to the neighborhood of
Okay.
White Rock, I believe it was.
Was the defendant
Look at that. The scene in Manatee County is where the death occurred. Crazy, isn't it? It's not the police station.
there?
Yes.
Where was she?
She was in the back seat of Deputy Burley's patrol vehicle.
Did you go into the house?
Not at that point. I did after the crime scene unit had already documented everything and made sure nothing could be contaminated, done their investigation inside. Then I went in briefly at the end.
Okay. And what did you see?
I saw some blood trail on the floor, a bullet strike in the wall of the bedroom from a projectile. And that's about it.
And were other members of your unit there at that scene?
Yes.
Were there other members of the unit at other scenes or other places?
Yes, detectives were also sent to our main offices, Criminal Investigation Division, which is where our interview rooms and our offices are located.
Okay. And from the beginning of when you arrived on scene, you knew that there was a self-defense element of this
Object
crime.
deleted. Sustained.
Did you know there was a self-defense element when you got there?
Object deleted.
Yeah, again, that's leading.
Overrule on that.
That's totally leading. She's guiding him into what she wants him to say. Do you understand the difference between saying, do you understand there was a self-defense element to this crime? And what did you glean, or what was your takeaway from the scene, or something? I can't think yet because I haven't had enough coffee, because at least I didn't dump my coffee all over the floor this morning yet. But you understand the difference. She's trying to guide him into the answer and just get him to say yes or no. It's not a proper question on direct examination.
Yes,
But wait, I thought he sustained that.
Sustained.
Did you know there was a self-defense element when you got there?
Object deleted. I'll overrule on that.
yes.
While you were at the scene, were you made aware that the defendant was going to be going to the station?
Yes,
Okay. Was the defendant's mother, Alicia Byers, there?
yes,
Did you speak to her?
yes.
And at some point, did she hand you a phone?
She did.
Okay. And did you know why she was handing you the phone?
Originally, no, but then
Okay.
I found out shortly after.
Who was on the phone?
A lawyer.
And did
Okay. Anybody with a half a brain or one iota of knowing the system would immediately call an attorney. Is she trying to infer that because there was an attorney on the phone, that means that this wasn't self-defense? It's called smart. She admitted to shooting him. She ran out of there screaming with the gun to the neighbor who called 911. She should absolutely have called an attorney, and I'm glad she did.
you speak to that lawyer?
Object. Sustained.
Did you explain to Alicia Byers what was going on and where her daughter was going to go?
I did.
And ultimately, how many lawyers ended up at
Relevant.
How many lawyers?
If you want to approach it, explain the relevance.
Yeah. I mean, is the inference we're supposed to make is that because she called a lawyer, she's definitely guilty and there's no self-defense involved here? This is a poor strategy, in my opinion. We have learned that there are six jurors on this criminal jury. 9 have been picked, 3 are alternates, 7 are women and 2 are men.
to the station?
It's only a 6-person jury in a criminal case in
At
Florida.
the time the defendant went to the station, was she under arrest?
No,
Was she ever arrested that night?
Object leading. Sustained.
When was she arrested?
sometime in November,
Okay. And the shooting happened?
in September.
And that seems to be a month or 2 delay. Do you know what delayed that?
But for the investigation to continue into the self-defense claim.
Okay. Did you go to the neighbor's house, John Sant?
I did go there briefly, yes.
Okay. And did you have any discussions with him or anyone?
I did not. No.
Okay. Was Child Protection Services on the scene?
Yes, they were called to the scene.
And just briefly, what is Child Protection Services?
Objection. Relevance. Consistent with the court's prior concern, 403.
Overrule.
What is Child Protection Services?
At the time, it was a division of the sheriff's office entrusted with protecting the children from abuse, or make sure they're in good locations, or just make sure they're healthy.
Okay. So why, do you know why they were there?
Objection. Sustained.
Did CPS try to speak to Alicia Byers?
Yes.
Okay. Were you present when
Yes.
Alicia Byers?
Yes.
Was Alicia Byers cooperative with them?
I wouldn't say fully cooperative. She did ultimately answer a vast majority of the questions, but not cooperative per se.
Okay. And was there anyone else?
For those of you who have had dealings or experiences with CPS workers in Florida, specifically Manatee County, I don't know if there's anybody here. Remember what happened with CPS in the case of Maya Kowalski? Some of the some of the counties in Florida are privatized. They were in the county that Maya's case was in, and they took her away from her parents. They assumed custody in that case based on false allegations. So are we going to hold it against her mom for maybe not wanting to cooperate with whoever from CPS showed up there? And by the way, just because she's not arrested doesn't mean that she doesn't have the right to remain silent and not give a statement. I don't like this line of questioning, and I don't think that there's older women on the jury. One of our viewers yesterday was in the courtroom, and she told us that of the 7 women and 2 men, most of the jurors were in their 60s, 70s, and 80s, and the youngest was a male in his 40s. So I don't know that the older women are going to like this line of questioning, just from my own point of view. It may look like bullying. It may look like trying to infer guilt from the fact that she didn't want to give any statements to the police, regardless of whether she was actually under arrest or not. So, quite frankly, if they did believe that there was no self-defense claim, they would have arrested her right away. Scott, let me know if you're right, if I'm right on that. This is September 27th. She wasn't arrested until sometime in November of 2020.
Present at the time when they were trying to speak to Alicia Byers?
Off and on, Barbara Russell was present.
Did you also assist in executing a search warrant?
Yes, I was on scene
And where was that search warrant? Was that at the house?
at the house.
Okay. Did you have any assignments for gathering evidence?
Yes.
And what evidence was that?
To originally look for video in the area of the park of the neighborhood.
And did you do that?
I did.
Were you able to obtain video?
I was.
And on that video, did you see what we believe to be Alicia Byers and the child at the park?
Yes, they were at the park.
Did you also obtain other types of videos?
Yeah, I also viewed ring video from the scene itself.
Objection. Relevant.
They had ring video.
What video?
Ring from the
Ring.
scene.
But overruled, I mean, you could say he viewed it.
And in viewing that, did you see any part of the incident that we're here about? Was it captured on the ring camera?
The shooting, no. The arrival of the U-Haul and the arrival of the deputies were on there.
Okay. I have no further questions. Thank you.
Pause.
How did that help? Except to get out that she called a lawyer because she's wicked smart.
Good morning, Lieutenant.
Good morning.
So through your testimony, among other things, the state proved this morning that there was a U-Haul truck there
Yes.
and that the deputies arrived
Yes.
and that there was a homicide.
Yes.
Okay. Now, you mentioned that often the practice is when you respond to a homicide, it takes some time to conduct an investigation to determine if there's criminality.
Absolutely.
Okay, so in other words, you don't come upon a homicide and determine as soon as you see a dead body, it's murder.
Correct.
Okay. If I wanted a job.
Imagine that. They didn't solve the case in 16 hours like Trooper Michael Proctor did. They actually waited to build their case to make the arrest. Remember, Karen Reed was arrested on February 1st, and there's how many days instead of 31 days in January. So 3 days post the murder of Officer John O'Keefe. They actually hadn't made up their minds yet. Imagine that. It's like a whole new world.
Bob, in your unit that you supervised, and I felt all homicides are murders.
Objection.
Boop. We're going to take that back because somebody in his unit did say, I feel that all homicides are murder. And I remember this briefly during the pretrial, but let's listen to his question.
Absolutely.
Okay, so in other words, you don't come upon a homicide and determine as soon as you see a dead body, it's murder.
Correct.
Okay. If I wanted a job in your unit that you supervised and I felt all homicides are murders.
Objection.
Fair question, Your Honor.
Objection. Pretrial ruling.
Sustained.
Jury heard it.
You mentioned that the arrest of Miss Benefield, well, let me start from, I think you told us she was in the back of the squad car.
Yes, sir.
She was in handcuffs.
Yes.
And this is a squad car with the doors that you can't open from the inside in the back, correct?
That's correct.
With a cage.
Yes.
So she's in the back of the squad car, in handcuffs behind her back,
Yes.
in a car with a cage, and you can't open the doors, but she wasn't under arrest.
No, she wasn't charged with anything.
Okay. So I think you told us that the reason for her being arrested approximately 6 weeks later, I think, was so that the investigation could be conducted.
Correct.
Because you had to determine if there was criminality.
Correct.
Okay. Could have been a homicide that was self-defense.
Could have been. That was the claim.
That's the whole point of the investigation.
Absolutely.
And that kind of an investigation, understandably, takes time
It does.
and patience
Yes.
and professionalism
Yes.
and knowledge and experience.
Yes.
Do you know how old Lieutenant Alicia Byers is?
I don't.
Do you recall meeting her?
I do.
Approximately, give us your best shot.
I mean, I would guess in her 40s to 50s.
All right. Was she a young woman?
No.
She was pretty exhausted that day, wasn't she?
She appeared to be. There was a lot going on.
Yeah. Would it be a fair statement, Lieutenant? You seem like a pretty straight guy. Was she emotionally distraught?
Yes, there's a lot of emotions going on there. Yes.
In fact, her first thought upon coming back from the park with the daughter and seeing the
Objection.
cars was
Hearsay.
that her daughter was
Please
dead.
stop
Sustained.
talking.
Just telling him to stop talking. Hold on a second. Let's hear what he said. First of all, don't ever ask a man to guess a woman's age. But he said 40s, 50s. So I have no idea how old she is. Her first thought was that her daughter was dead when she got back and saw the police cars. So hold on.
She appeared to be. There was a lot going on.
Yeah. Would it be a fair statement, Lieutenant? You seem like a pretty straight guy. Was she emotionally distraught?
Yes, there's a lot of emotions going on there. Yes.
In fact, her first thought upon coming back from the park with the daughter and seeing the
Objection.
cars was
Hearsay.
that her daughter was
Please
dead.
stop
Sustained.
talking.
It's out there.
Unless you'd like to make an argument for an exception, then you can approach.
Rest gesti?
Well, if you'd like to approach.
It's all right, Your Honor. I think, Lieutenant, excuse me, you told us that you went into the residence after crime scene had completed their portion of the investigation.
Yes, sir.
And do you recall crime scene was there, before or after EMS?
A crime scene comes after EMS. The sanctity of life always comes first.
All right. So EMS was there first, and you were there, so you know they dragged Mr. Benefield out of the home from
Yes.
the bedroom.
Yes.
So when you told us that crime scene was there to preserve the scene, can we agree, Lieutenant, that what crime scene preserved was the scene following the EMS people, not only working on him in that bedroom, but moving?
Yes. As always, that we preserve the scene after we attempt to save the life.
Okay. And so those crime scene photos show us, for example, what that scene looked like when crime scene took the photograph.
That is correct.
It doesn't show us what the scene looked like when EMS was running around doing what they do.
That's not possible. No, that's correct.
Okay, and that would have included the initial deputies on the scene as well.
That's
God bless
correct.
you. Give me just a moment, Your Honor.
Yes, sir.
I like this lieutenant. I find him to be very kind and gentle. And if I was ever in a situation where I was emotionally distraught, I would hope there would be someone like him, a calm, soothing presence. What say you?
Thank you, Lieutenant. Appreciate your candor.
Thank you, sir.
That's all.
Appreciate your candor, he said.
Yeah.
Can this witness be released?
Yes.
Mr. Taylor, can this witness be released
Yes,
from your
sir.
subpoena? Sir, you were released from your subpoena. You're free to go.
Yes, sir. Thank you very much.
All right, Stacy?
Can we approach?
Approaching. Hope she doesn't say that's it. That's all the witnesses I have for today. The prosecution said yesterday their case may be over by tomorrow. So that's interesting. And I don't think the defense has a whole lot of witnesses to
Take our
call.
mid-morning break. All right, members of the jury, we're going to go ahead and take our mid-morning break right now. So you can step back into the jury room. Please close your notes, leave them right where they are. It should be 10 or 15 minutes. Stretch your legs, get something to drink back there, use the facilities. Please don't begin discussions amongst yourselves. You are free to still use your cell phones to send and receive text messages, calls, anything like that. But please don't discuss the case outside of this group and don't do any research on the people, places, things, or legal topics we've heard anything about. Thank you.
ML, you all who think 60 years old are in for a big fat surprise. Look at Robin. Robin's like, I'm in my 70s. I feel like I'm in my 40s. That's right.
All right, y'all can have a seat. We'll be on recess. We got, bless you, 10 minutes.
Somebody said Jules was in the courtroom. I didn't see her. I guess I wasn't really watching the background. Ashley has her hair down today, so I'm sure there's gonna be people out there criticizing that. Yesterday they didn't like her. They were calling them jailhouse braids. Meanwhile, she's been out on bond, $100,000 bond with an ankle monitor for the last 3.5 years or so, almost 4 years, with an 11 p.m. curfew. I'll have that up on the other screen, and let's go to some questions. On top, good morning. Thank you for being on top of the super sticker so early. Welcome, Amy, Ohio, new member. Pilgrim Shadow with the Morning Grateful Dead quote. Ain't no time to hate. Uncle John's band. That's a great line. So many lines in Grateful Dead lyrics that could apply to just about any type of situation, any day of the week. Dickless Tracy says, thanks for being a class act. Thanks for being here, for being a member for 2 months. Bianca became a new member. Welcome. Lady in Boston, good morning. Thanks for the deuce. State of Florida is pulling a lally, she says. And Kimmy, how did she call a lawyer being in the cop car? Her mom did. Her mom handed the phone to that lieutenant. and said, I have her lawyer on the phone. And it's not surprising that she had a lawyer. She had a pending DV protective order that there was scheduled to be a hearing on a couple of days later. There was a custody battle that I don't even know if the custody battle was ongoing. They were sharing custody since something like 2019. So there's been a lot of information out there about what proceedings were still pending. Yes, Donna. Oh, wait. But it was only a few hours at 1 a.m. and Ashley already had legal advice. Donna, I think we have covered that. That is the smart thing to do. And she already had lawyers on retainer. Donna says the wife has done a lot to avoid statements, but how would her daughter not tell her what happened after she killed her husband? Listen to the people in the chat, Donna. There's a lot of survivors here. A lot of survivors here. And I think that they can give you better answers on that than I can. So if anybody would like to respond to Donna G, let Donna G know why you think that she did not tell her mom exactly what happened or they did not discuss it. Laura wants to know, is the doctor bound by confidentiality? She is for any therapist-patient communications. The patient can waive the confidentiality, but the doctor wasn't asked any confidential questions. The therapist, she's a social worker. Did she say she has a doctorate? She may be, but she's not a licensed, I guess, psychologist. She has a licensed social worker. Thank you. Blakey on pause says true crime is littered with CPS misjudgment. Harmony Montgomery, Gabriel, Maya Kowalski, the baby that was put in the box and put in the water. I can also name Tommy Valva from right here in New York on Long Island, and probably many others that we can think of. Thank you to Lady Libra and also to Gail Taylor, who both became new members today. Morning break. We're on morning break, everyone. It's only a couple of more minutes until we go back. Somebody just said, wow, this is refreshing. I know it's going to take some time for people to find us, but if you've tried to survive out there in any other chats about this case, you will be attacked. You will watch things that you never thought any sane person would say fly by in the chat. And it's kind of scary. Tommy says no one wants to make their parents worry. That's a great point. Amy also says lawyer tells you not to tell anyone, right? Don't discuss this case with anyone. Lawyer also said do not discuss this case with anyone. The taillight confetti fairy. Oh, I love that. I love when you guys change your screen names to match the cases that we're covering. Says I still don't talk about it, and it's been 5 years. My mother and sisters don't ask. It's not abnormal. I don't think it is. Shaylee said she didn't tell her mother because that way her mother couldn't be questioned in court against her. That's a great point that a lot of people might not have thought about. Lady Lieber says, I really feel for Ashley, and this case triggers me. I hope you haven't tried to brave it out there in any other chats, because the hatred for Ashley out there is real. People are real open about it, behind fake names, of course. They don't get it. They don't get it. We get it. Animal Lover says, my stepmother made a false report to CPS in an attempt to take my oldest daughter because she didn't like my husband and I wouldn't leave him. They didn't have a reason not to like him. That's the thing about CPS reports. You can make them anonymously. And so you can be faced with a CPS report by an anonymous person and they don't have to tell you who made the report. It's kind of scary. Cakes Boo says, I would call a lawyer in any situation these days, and not going to lie. Queen of Ravens, can take years before you're ready to discuss traumatic events. 100% true. Amy Lou says it's triggering to talk specifics. Nicole Corda Scarapicia, why have you already decided this was actually self-defense? So what I've decided is that in the United States, defendants are innocent until if and proven guilty. So that's the way we're looking at it here. We haven't heard all the evidence yet. And so far, I haven't heard any evidence that says that it wasn't. And the burden is on the prosecution to prove the case, not the defense. It's on the prosecution. So that's the way we roll here. If you don't like it or don't like what we have to say here, there's a lot of other places that you can go watch this coverage. But since you were respectful about that comment, unlike so many others, maybe you'd like to stay and listen and hear from people in the chat who have been survivors of the most brutal things that you can imagine at the hands of a spouse, both men and women. And so here in this chat, we believe victims until we have reason to believe otherwise or until the state can prove otherwise. And that's the way we roll here. And I pretty much think maybe we're the only other channel out here that does that. Because although Ashley has never given a statement publicly or to the police, pretty much everyone else out there has already convicted her because of the way she looks, because of her age, because they think she's a gold digger. So that's the way we roll here. Thank you, Sonia Pedro. I fell in love with your fashion of covering trials. You're professional and your candor is a gift. Thank you. And love for Portugal. Thank you for tuning in from Portugal. And thank you so much for your very generous super chat. I appreciate you so much, Sonia. Some people don't like it. They come on here, you're biased. You're so biased. It's my channel, right? Last time I checked, my name was on the channel. It's my channel. There are channels out there who will just put their picture next to the feed, never say a word, and you can watch it without hearing any commentary. This is a commentary channel. That's what I do. And I'm not afraid to share my opinions and my thoughts, and neither are you, my friends.
Please, we need to get started.
It's coming back. Majin, thank you for the super chat. I'm a bit behind, but how is talking about retaining counsel and implying she maintained her right to silence, not getting the prosecutor hammered? Well, the jury is the finder of fact here, and so the jury makes their own determination about what they think about those questions. And so that's a great question. That's the way I took it as well. Any smart person would call an attorney. Thank you. Thank you for your super chat. Yes, Sarah, some chats are shocking. For example, here's Carly's story. My mom didn't know I was abused for years and only then thought it was the one time because that's what my abuser said. I was ashamed. Nixie says, my mom still wonders why I stayed. Oh, thank you, Kimberly. Jules is in the courtroom. Okay, we'll look for her.
All right, welcome back, members of the
There she is. She's right there in the black shirt, right behind Ashley.
Started deliberations amongst yourselves, talk with anybody outside the jury about the case, did any research on the people, places, things, or legal topics we've heard anything about? No? All right. State, call your next witness.
State calls Stephanie Murphy.
Stephanie Murphy is, I believe that's the
Yes.
attorney for. Stephanie Murphy is the attorney who represented Doug Benefield. And I'm not sure in which proceeding she represented him in, custody or the orders of protection. Terry says, Mom, teach your daughters young. Yes. Yes. Kooky Caroline says, if you're manipulated to believe that everything is all your fault and you're blocked from your family and friends, it's pretty damn hard to, one, understand the situation, and two, have the guts to talk. And so you are hearing in this chat from real survivors who can give us more understanding about what victims and survivors go through. Linda the Mighty Mouse says, I think a lot of the people are jumping to conclusions based on what the defense lawyer is saying, but a lot of time those things are false or not proven. I've researched this case immensely. In your opinion, she's guilty. In your opinion, she's guilty, but you haven't heard from her. You've heard what the narrative has been out there, right? I haven't heard anything yet that proves to me that this was not self-defense from this prosecution. And it's their burden, remember.
Hello, ma'am.
Good morning, Judge.
My name is Judge White. I'm going to be presiding over the case. Get yourself about 12 to 15 inches from the microphone. It does adjust up, down, left, right. Just make yourself comfortable. If you speak directly into the microphone with a loud, clear voice, we'll hear everything.
Thank you.
Thank you.
Somebody in chat said they couldn't hear the judge. Can you guys, the volume okay for you guys? Because I'm hearing it okay. Let me know if we need to switch over to a different channel, but I can hear it fine. Kim Farnham says her dress matches my chat.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
How do you spell first and last name?
Stephanie is Stephanie. Murphy is Murphy.
And what is your profession?
I'm an attorney.
How long have you been an attorney?
This is my 23rd year as an attorney and actually in the Sarasota Bradenton area.
And are you with a firm, sole practitioner? What do you do?
My husband and I have our own firm, and I've had that firm for 16 and a half, 17 years. Before that, I was at a larger firm in Sarasota.
And what is your topic of law that you practice?
I practice family law, which is generally comprised of divorce, custody cases, or what used to be called custody cases, and adoption cases.
Okay. I want to ask you about Doug Benefield. Did he hire you?
He did.
And approximately when did he hire you?
He hired me in March 2018. He came for a first consultation on the 13th. He hired me on the 14th of March 2018.
And what was the purpose of your duties to begin with?
Initially, the purpose of hiring me was to draft a letter to Ashley Benefield, who was pregnant with their child at the time, which I did. I drafted a letter and sent it the day after I was retained. But the purpose of that letter was actually just to initiate.
Relevance. She stated that she sent a letter, that she was retained to send the letter. Now going to explain.
Ha ha ha. Good one, Donna. Let me guess. Murphy's Law.
What was the purpose of the letter?
The purpose of the letter was to open the door for discussion about Doug's participation in the upcoming birth of their child, but also to advise that if she did not feel comfortable with him being present at the birth, he was respecting her need for space.
And when did you send that letter?
I sent that letter on March 15th at 9:59 in the morning by email to Ms. Benefield.
And did you receive a response to that letter?
I did not receive a response directly from Ms. Benefield. She checked herself into Tampa General the next day to start induction.
Sustained.
So
She checked herself into the hospital to start an induction. I'm sorry, but wouldn't a doctor be the one to proceed with an induction of childbirth under necessary circumstances? People are asking in the chat about attorney-client privilege does survive death. So just because your client is dead doesn't mean you can breach attorney-client privilege. I guess they can ask in general terms what she did, but they can't talk about any conversations between Doug Benefield and her as his attorney. So there's a fine line that needs to be walked here, unless they've made some other pretrial rulings that I'm not aware of.
when was the child born?
Well, the child was born early. She was born on March 19th, I believe, is when she was finally born.
And
Finally born.
you said early. How many weeks early was that?
Well, the child was originally scheduled, or her due date was April 8th. So I think
Sustained.
Hearsay. How would she know that?
So you said you never received a response
not from Ms. Benefield.
from Ms. Benefield about the letter.
Correct.
And to your knowledge, did Doug ever receive a response to that
To
letter?
my knowledge, he did not receive any response from Ms. Benefield or anyone on her behalf.
And I think you might have said this, but the child was born on what day?
She was born on the 19th of March.
And at the time the child was born, did you or Doug know that the child was born?
No, gosh, we didn't know for a good 5 or 6 weeks after she was born.
Okay. And how did you find out?
No, gosh, we didn't know. It was an email. Thank you. Thank you, Shannon. It was an email. Not everyone checks their email constantly. In cases like this, you would send a certified letter. Return receipt requested with that little green card on the back. So somebody would have to sign for it. 2 weeks early is not a big deal. Moms of twins know.
That the child was born?
I actually found out because I had been monitoring the docket for Manatee County court system, just because there had been no response. And so on May 6th, I saw that Ms. Benefield had filed a petition for protection against domestic violence on, I think it was April 23rd. So about 2 weeks prior to me finding out, she had filed the petition. And in that filing, there was, she identified the birth date of the child, as well as I think the child's name, which is the first time we learned about that too.
Okay. And you said she filed a petition for, what did you call it?
It's a petition for protection against domestic violence. So it's an injunction. A lot of people refer to it as a restraining order, but it wasn't granted as an injunction at the time.
Okay. So when, just for knowledge of people that may not know, when someone does a request for an injunction, what is sort of the procedure that it needs to go through?
So a person who files a petition for an injunction, they file it at the courthouse in the clerk's office, and then that gets sent up to the judge, usually a family law judge who's just in charge of injunctions that day. And then the judge has 3 options, I believe. One is just to deny it completely. The second option is to grant a temporary injunction, but then there's a follow-up or a return hearing.
I'll overrule.
And then the third option is what happened in this particular case, is that the judge denied the petition as a temporary injunction. So there wasn't enough evidence in the petition to warrant a temporary injunction, but a hearing was set to review it.
Okay. And when was that hearing set approximately, to your knowledge?
I believe it was originally set for May 8th, but Ms. Benefield made a request to continue that hearing.
Okay. So it was then continued?
It was.
Before the hearing actually happened, did you file any documents on Doug's behalf?
I did. So, well, of course, I filed a notice of appearance in that injunction case. And then we started an entirely separate case. So I filed on Doug's behalf a petition for a parenting plan unconnected with divorce. And so he wanted to establish a parenting plan so that he had really time sharing and decision making for his daughter, because he had none of that up to that point because she was withholding all that information.
And some of the lingo may be familiar to us, but so time sharing, what is that?
I'm sorry. So time sharing is what lay people and a lot of people used to generally call visitation. So it used to have custody, parent had custody, and then another parent had visitation. That was changed. And now in Florida, at least, and especially in our circuit, we have parenting plans, which is a comprehensive agreement or an order by the court that lays out all the details of parenting as a not intact family. So the major components are decision-making and time-sharing schedule. So how often the child spends with each parent.
And you said not connected with a
Time sharing to be distinguished from time sharing as in the worst possible investment that you can make in buying a timeshare property, like a 1-week vacation at the place that you buy into for the rest of your life. This is Eva Benefield, Doug's daughter. She was 15 at the time that he secretly married Ashley. She's 23 now. She testified yesterday. If you didn't watch it, I suggest that you go back and watch it. We did 2 streams yesterday, one in the morning and one in the afternoon.
divorce proceeding.
Right.
So I would assume that
Wait,
means
let
it
me
can
take
either
that
be
back.
with-
Because there was no divorce proceeding pending. Nobody had filed for divorce, so he's filing for what they're now calling time sharing.
So how often the child spends with each parent.
And you said not connected with a divorce proceeding?
Right.
So I would assume that means it can either be with a divorce proceeding or without.
It can be, and of course, it can be also in a paternity case, so parents don't have to be married. But in this case, because they were married, Doug was not initially pursuing a divorce because he hadn't had any contact with Ms. Benefield for a while. His initial,
Sustained.
So initially it was not connected with divorce.
right, his priority was his daughter.
And you mentioned the injunction case and then your motions. Were they two different case numbers?
They were two different case numbers. So the injunction case number was 2018 DR 1823. And then the new case that I filed for Doug was 2018 DR 2318. Now they're companion cases though, so they might be separate cases, but they travel together as companion cases and they're assigned to the same judge through this unified family court program.
So when the hearing was set and ultimately heard, were both of those case numbers heard?
Both of the case numbers were heard, but it wasn't our first pleading wasn't the same pleading that was heard at the time of the injunction.
Objection. It's narrative, non-responsive to the question.
Sustained.
So what generally were the allegations in the injunction petition?
Generally, Ms. Benefield was alleging that Doug had been violent toward her. She alleged that he, I think, had hit the dog, fired a gun into the ceiling. The biggest allegation was that he was poisoning her and their child in utero with heavy metals.
Okay. When was this?
And that's why she went to the hospital, my friends, because she thought that she was being poisoned. She thought it may have affected her unborn baby. He used to bring her tea every night and in the morning. And in the opening statement, her attorney said the tea was unusually sweet. She thought she was being poisoned. And during pretrial, we learned that she got some results from a lab, and it showed that she had very, very high levels of heavy metals. We'll see how much of that's going to come in. But it sounds like the attorney didn't believe any of these allegations. That's just from her tone. That's what I'm getting from her.
Hearing finally held?
The hearing was held in two parts, actually. It was July 30th, and then the second part was September 17th.
Not responsive to the question, Your Honor.
Overruled.
And that was the year 2018, correct?
Yes, it was.
Okay. And what judge was this in front of?
It was in front of Diana Moreland.
And you said it was held on 2 days. Why was it held on 2 different days?
It took a very long time. So
Okay.
both sides had experts, toxicologists, and we had a number of other witnesses appearing. We had,
Objection. Not responsive to the question.
Overruled.
there were also people from the child protective team testifying. And so there were too many hours. And so we couldn't squeeze it all into one day.
Okay. And ultimately, at the end of this, did Judge Moreland make a decision?
At the end of that, she did. There
I'm
were
sorry.
other decisions along the way, but ultimately she made a decision on the two matters that were set as the companion cases.
And what I meant was on the second hearing day, did she make a decision?
Yes, she
Okay.
did. September 17th.
And what was that decision?
There were two parts because, there was two cases.
Objection, Your Honor, just final decision.
For the prior motion,
Yes.
overruled.
Go ahead.
Thank you. For the injunction, she made a lot of rulings and a lot of findings about lack of evidence and then denied the petitions.
We don't want to talk about
Oh.
what went into that. We just want to know what her
Gotcha.
ruling was.
Okay, she denied the injunction. So
Okay.
that was the first part.
Okay. And then the second part.
The second part was on the parenting plan case, the time-sharing case. And so in that, she entered a ruling for a time-sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and otherwise shared decision-making.
Overruled.
And otherwise, I'm sorry.
Otherwise shared parental responsibility, which is joint decision-making.
Okay. And as of that day, was Judge Moreland's ruling timed? Like, was it immediate? Was it in the future for the time sharing? of the
It was
child?
immediate. Well, not that day, but she said the first day, and it was just a couple of days later, the 21st, which is when Doug was supposed to meet his daughter for the first time.
Okay. And this time that Doug met his daughter for the first time, were you present?
I was, yes.
And where did this happen?
It happened at Manatee County Sheriff's Department on, I think it's 301.
Did you arrive together or separate with Doug?
Oh, we arrived separately. When I got there, Doug was already there.
It's interesting that the judge did not grant her a restraining order, and yet the exchanges had to be done at the sheriff's department, right? Which is usually done in contentious cases. So there's that. Judges don't always get it right.
And how old approximately was the baby at the time?
I think she was around 6 months old. She was born in March, and this was then the 21st of September. It's about 6 months.
And can you explain how that interaction went? Did you observe it, first of all?
I did.
Okay, and
So
how
when
did-
I arrived, I got into Doug's truck and we just waited because we were there early. And then he saw Ashley arrive with the baby. And so he pulled the truck closer, and then we both got out of the car and started walking toward Ashley. And then it was just an odd kind of interaction, actually. She
Objection.
turned to me with this nasty look on her face.
Objection. With this nasty look on her face. She's allowed to talk about her observations, not her conversations with her client. But her characterization of Ashley having a nasty look on her face and that the interaction was odd may rub the jury the wrong way. Take it back a sentence.
And started walking toward Ashley. And then it was just an odd kind of interaction, actually. She turned to me with this nasty look on her face and said to Doug,
I'll sustain as to the characterization.
she turned to Doug and said, "Are you dating her?" And so obviously we both said, well, of course not, no. And then I hung back, and Doug then was standing there, and Ashley approached him.
Why would the attorney go with Doug to meet his daughter for the first time? Why would the attorney be accompanying him to the exchange? That's weird. That's weird. So he shows up with this woman and she says, "Are you dating her?" And this woman seems taken aback, this attorney, like, "Oh, why? Are you crazy? Are you kidding me? Why is she even there?" Okay, that's just weird. I need to hear that again. Boundary issues everywhere. Why is she going to the sheriff's department on the day that Doug is meeting his daughter for the first time? What? Okay, here we go. I want to hear it again. But she's quick to point out, and Ashley had a nasty look on her face, and it was a very odd interaction. I don't think it's that odd. What were you doing there? And why does she hate her? Yeah, it seems like she hates her, right?
The characterization.
She turned to Doug and said, "Are you dating her?" And so obviously we both said, well, of course not, no. And then I hung back, and Doug then was standing there, and Ashley approached him with Emerson, and they started talking. Eventually she let him hold the baby, and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time
Strangely.
sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with.
Why is she saying we instead of they? Word choice is very important to lawyers. Weird vibes here. We had just been in knockdown, drag out litigation. No, they had been in litigation. You're the attorney. You're not. That's like when the waiter comes over to your table at a restaurant. Here's another one of my pet peeves. It says, "Have we decided what we'd like to have?" Well, we have. You're not eating with us. How are we doing tonight? I don't know. We are fine. How are you? It's just bizarre. we had been in litigation. No, they had been in litigation. I have to play this again because this is really standing out to me as quite bizarre testimony. What is we? Yeah, she said we all the time. Weird vibes. Okay, here we go. I'm taking this back. This is what we do here. We rewind, we talk about it, we dissect it, we analyze it, because this is weird. She almost, it feels to me like she's almost like feeling rejected, like they went off on their parenting time together, and that's so weird. I don't think it's weird for a woman who's afraid to leave her new baby with someone she's afraid of. Wow.
Was standing there, and Ashley approached him with Emerson, and they started talking. Eventually she let him hold the baby, and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with just horrendous allegations that were unfounded. And yet she said, I
Objection.
want to go with you. And he said, okay.
Objection to the characterization of the allegations being unfounded and continued editorializing by this witness.
Yeah, I agree. He said, I'm objecting to the characterization of unfounded allegations and the continued narrative of this witness. GV says, sorry, Aruba, but we named Mean Girls Aruba Chicks. Giving you Sullivan sister vibes? Thank you. Thanks, GV, for the super chat. Gritted teeth. She got into Doug's truck. All right, hang on. I'm taking this back again because this lawyer, I'm going to submit to you that she knows what she's allowed to testify and what she's not. And the fact that she's mischaracterizing, embellishing, adding superlatives onto her testimony, it's not a good look for her. Horrendous allegations. She calls them horrendous allegations. Hopefully we find out what the horrendous allegations were. Taking it back. Here we go.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with just horrendous allegations that were unfounded. And yet she said, I want to go with you. And he said, okay.
Objection to the characterization of the allegations being unfounded and continued editorializing by this witness.
Continued editorializing by this
Sustained.
witness. And that's sustained. Oh, they're approaching now. Yeah, she's the lawyer. She should know better. She's sure putting on a show. Thanks, Randy. Amanda, she sure is putting on a show. Wow. Did she travel there with Doug in the same car? Smiling at the jury.
So when they told you they were going together, what was your response?
I pulled Doug aside and I cautioned him about going with her. I advised, his attorney, and so I did advise him. I said, this isn't a good idea. She's trying to set you up for something. Don't do this. And he said, I understand. I'm going to go ahead and do it anyway.
Wait, why is this not privileged? Why are these conversations not privileged? Does Florida have a bizarre law that attorney-client privilege disappears upon death of your client? Because that's not the way we do it here in New York. What? She's testifying as to their conversations. This is really weird to me. Hold on, here we go.
His attorney, and so I did advise him. I said, this isn't a good idea. She's trying to set you up for something. Don't do this. And he said, I understand. I'm going to go ahead and do it anyway. And so I stayed and observed as Ashley strapped the car seat into the back of the truck, and she got in the truck with Doug, and then they left together for his first time sharing with his baby.
Okay.
Their baby.
So after this
She sounds mad about it.
first time sharing, did this seem to start a time of peace, so to speak?
It was a time of peace. Actually, before the 26th, but on the 26th, Doug and Ashley both signed a stipulation that I had drafted at Doug's request, which expanded the time sharing that Judge Moreland had ordered at the hearing on the 17th. So within a week, they had already agreed that he was going to have even more time sharing than Judge Moreland had said.
Okay.
And so that was filed in the court file. It took away the restriction of meeting at the sheriff's office if they chose.
Non-responsive.
Overruled.
So yes, that was the beginning of a time of peace that extended for quite a period of time.
And during this time, well, how long did that last, the peace?
It lasted, to my knowledge, about 11 months.
Okay. And during this 11 months, did you see Doug and Ashley?
I saw them in magazines. Actually, they were attending gala events together, and so they were kind of the
Speculative and hearsay.
Overruled.
So other than seeing them together at the sheriff's office, I didn't personally observe them out in public, but I did. Like I said, I saw them in various forms of media. They're quite the couple.
Okay. And you said this peace lasted about 11 months. What broke this peace to your knowledge?
Well, it was my understanding from Doug that they were getting
Jeannie Marie says, yeah, she's mad her client is dead. Then why is she laughing throughout her testimony? I'm not getting that vibe at all. She saw them in magazines. They were quite the couple.
ready to move in.
Oh, unless you mean she's mad that her client's dead and not paying her anymore. I'm not sure. Are they going to show these magazines that they were photographed in? Quite the couple.
Peace to your knowledge.
Well, it was my understanding from Doug that they were getting ready to move in.
Yeah.
Let's not talk about what happened with what Doug said was supposed to happen. But during this time, did Ashley stop speaking to him?
I'm sorry, I didn't hear the question.
During this time, did Ashley stop speaking to Doug?
Objection. How would she know? It calls for
How would
hearsay.
she know?
Effect on the listener.
Team Brittany, objection, jealousy.
Thank
It's a
you.
good one.
They continuously spoke to one another for 11 months until August 16th of 2019.
Objection. I thought that was a yes or no question. Objection, non-responsive.
This is objection. I thought that was a yes or no question. Non-responsive. Sustained.
Around this time, you said November 16th?
August 16th,
August 16th.
of 2019.
Okay. What happened at this time?
Doug was supposed to be moving in with Ashley and her mother, Alicia. He had moved all these things in.
And we're not going to talk about the specifics of that.
Sir, counsel, I'm sorry to interrupt. Your Honor, I request the instruction from the court about,
Can we not do speaking objections?
Do you need to approach?
Yeah, approach, please, because this lawyer seems to know an awful lot about what Doug and Ashley were going to do. And that seems to be stuff that she would only learn through attorney-client privileged conversations if she even did know. So it's weird. And, you know, we're assessing witnesses the same way the jury's going to assess witnesses.
All right, members of the jury, this is one of those situations that's going to take us a few minutes, so I'm going to excuse you back to the jury room.
All right, he's sending the jury out, so let's see what they argue about now. But this is interesting. She's being told not to look at anything or talk to anyone or do any outside research. She just rolled her eyes, someone said.
Judge, I don't have a specific instruction. We may need to craft one, but what I'm looking for so that the court knows is an instruction to the jurors that these hearsay statements that have been repeated by the witness thus far, and for purposes of the remainder of her testimony, the other statements she will undoubtedly try to get out, are are not being offered for the truth of the matter, but rather being offered for whatever reason that the court wants to ascribe to provide the context of the narrative in response to the question.
So as I said, go ahead, do you want to be heard?
No.
So as I said, I'm not aware of a standard jury instruction in the 2.1 to whatever it is, 2.8 range or 2.9 range that does that very thing. So I want to give the parties the opportunity with the jury not present to look and see if there is a standard jury instruction.
I don't think.
I can give it. Like I said, I drafted one for a prior homicide trial where there were a number of statements that were admitted by me, by the decedent, where there were objections, just like we're having now, numerous objections to hearsay. But obviously, none of them were being offered by the state for the truth of the matter asserted. That's what was argued, and I made that finding. So in order to have just a blanket instruction, I crafted the following, and the parties ratified it. So I gave it specific to the decedent's statements in that case to, it was either an attorney or some sort of financial planner about some final wishes. And here's what it says. You are about to hear statements made by declarant, and I put the name in. These statements are relevant only to explain the reaction and responses that they elicit. That is, the effect those statements had on a reader or a listener, because there was also a letter that was involved. You are not to consider the statements by declarant's name as true, but only to establish the context of readers or listeners' actions, reactions, and responses.
That'll be fine.
Except for that you are about to hear me, because they've already heard some, so.
So the court want to substitute, you've already heard and may continue to hear.
That's a good compromise.
And by suggesting that, I'm not suggesting that I agree to the further admission of hearsay or her interpretation that's not directly responsive to the question.
So reserving on other objections. And certainly there may be objections you have as we go where you think that they are not being offered for the effect on the listener and that it's hearsay without exception. So those still may come up. All right, so when we bring the jury back in, you want me to give that instruction?
Please.
You have heard and may continue to hear statements made by Doug Benefield to Stephanie Murphy. These statements are relevant only to explain the reactions and responses that they elicit. That is, the effect those statements had on Ms. Murphy.
If I may, Your Honor?
Yes.
I would suggest that it just name Stephanie Murphy, not Doug Benefield, because I think in her testimony it's been broader than that. So I think by identifying the instruction as it relates to this witness, the jurors will consider the testimony appropriate.
All right, so let me go through this again because I have declarant and recipient, reader or listener. So you have to tell me where you're talking about.
Sure.
You are about to hear statements made by Doug Benefield.
Yeah.
These statements are relevant only to explain the reactions and responses that they elicited. That is, the effect those statements had on Ms. Murphy. You are not to consider the statements made by Doug Benefield as true, but only to establish the context of Stephanie Murphy's actions, reactions, and responses.
Okay, so here's my concern. For example, Ms. Murphy also testified about Judge Moreland and about a couple of the medical records and things like that. And I would prefer, and I think the fairest interpretation would be, ladies and gentlemen, Stephanie Murphy has previously said and may continue to refer to out-of-court statements. You are instructed that these statements, if and when made, are not, you should not consider them for the truth of the matter asserted, but rather for context as it relates to Stephanie Murphy's testimony. That's how I think appropriately it should read, Your Honor.
Response?
Judge, I think these things that he's talking about were objected to and they were stopped. So I don't know that it's better to highlight it anyway, but I don't know if adding names in of people to fit this, statements of Doug Benefield, this person, that person, this person, I don't know that that would be effective to the jury. So I'm a little confused about how to handle it.
All right. Any final thoughts?
No.
All right. I'm open to giving limiting instructions, curative instructions that are suggested by the parties. However, the most recent one proposed by the defense, I don't think is legally accurate. It would be telling the jury to disregard testimony and evidence that's already been presented. I thought the request from the defense, because the objection came specific to Doug Benefield was supposed to move in with the defendant, and that's where we stopped. So it was my understanding that the instruction that was requested was specific to any statements made by Doug Benefield to Stephanie Murphy, that those are only relevant to explain the subsequent actions and effect that those statements had on Miss Murphy, and telling the jury not to consider the statements by Doug Benefield as true, but only to establish the context of Miss Murphy's subsequent actions, reactions, and responses. I don't think the limiting instruction proposed by the defense is the correct one to give. So I'm open to considering language that we can talk about some more, but no, the one you just said I don't think is appropriate.
All right, well, the message that we're trying to give the jurors is that when this witness makes hearsay statements, that the jurors should not necessarily receive that information as true, that it is being offered rather not for the truth, but to show the effect that it had on this witness. After all, that's what this witness is testifying to. She did not limit it just to what Doug told her, Judge. She's referred several times to what she heard from Ashley. She's referred to medical records and to allegations. She's also referred to Judge Moreland's decisions. She's expanded upon them. She's incorporated hearsay into her testimony. This was why I approached the bench before she took the stand. So I anticipated this. That's the way she's conducted herself in the deposition and in all of her prior statements. So what I want, respectfully, Your Honor, on behalf of Ms. Bennett.
There's nothing that I can do. Brinley is saying that the audio is low with the defense lawyer. He's not probably close to a mic, but The judge is loud. He's got a mic. That's why I have the closed captions on, although don't rely on them because they refer to motions in limine as motions in lemonade, which is what we have cheerfully called them for all time now. If I gain up the audio, it's going to blow your ears out when the judge talks. So the best that we can do is try and follow along with the closed captions or turn your device up as high as you can when he comes on and then turn it back. But I can't control the audio for every single 2,839 of you that are here, which, by the way, if you're here, thank you. Please hit the like button. I think you're going to like it here.
Benefield, what I want the jurors to understand is that as it relates to Miss Murphy's characterizations based on hearsay, that they should not receive it for the truth of the matter asserted. Rather, they should receive it to show the impact that it had on Miss Murphy.
Response.
Judge, first of all, anything that Ms. Benefield said is not hearsay, so it does not qualify under any of this analysis. I do not believe she said anything about medical records. I may be wrong. She did start to mention that she checked herself into the hospital. There was an objection and she stopped speaking. So I would agree that that your idea is correct and that should be the instruction.
Final thoughts.
So, everything that a defendant says is not necessarily admissible. It's not necessarily relevant. It's not necessarily an admission. For example, Judge, if during the course of all of this, Ms. Benefield may have stated how much she loved this routine of a mouse named Topo Gigio, I think we could agree that that would have no relevance. And if this witness wanted to get up and talk about that merely because that is something that Ashley Benefield repeated, that wouldn't make it acceptable. So I vehemently disagree with Ms. O'Donnell's statement that anything the defendant says is admissible. And I'm concerned about the editorializing by Ms. Murphy being interpreted by the jury as truth, as unvarnished and documented conclusions. And so I would like the jurors to know basically the definition of hearsay. I would like the court to instruct them that it's not being offered for the truth of the matter asserted. It's an exception, and it can be considered to show how this witness reacted to it. And that way, Judge White, it expands the parameters wide enough that the instruction would include hearsay from any source that Ms. Murphy refers to, whether it be Ms. Benefield, whether it be Doug Benefield, whether it be the hospital records, or Judge Moreland.
All right, thank you both very much.
Jules is in the courtroom today. Coffee cake.
At this point, I don't plan on giving any sort of cautionary or limiting instruction. I heard the parties agree on language. It doesn't sound like the language I've suggested is acceptable to both sides. So at that point, we'll just continue with the question, objection, ruling. Specifically as to the request regarding editorializing and characterizing, I'm going to sustain on those grounds. There's been, I think my information in front of me is that Ms. Murphy is a fact witness. The request that I give the definition of hearsay to the jury is denied. As we all know, the determination of legal matters, including whether a statement is hearsay or not, or any sort of evidence is hearsay, that's a judicial matter not a legal, it's a legal question, not a factual question for the jury. Those are my decisions. I'll note that it is already factored into a court's ruling if a statement is offered, if an out-of-court statement is offered to prove the truth of the matter asserted in the statement, it is hearsay. The issue then becomes, is there a recognized exception to that statement or to that hearsay? And is it relevant and material to the case? That's how I'll continue to make my decisions, subject to the objections and the arguments that are made. Are we ready to bring the jury back in?
I did have one scheduling question, if it's okay with Your Honor.
All right.
We have, after Ms. Murphy, we have 2 law enforcement officers here. And then our next witnesses are Dr. Broder and Dr. Quintal. Do you feel like I'm safe in telling them they could come after lunch? That was when they were originally scheduled, but they have patients and they're asking if they need to cancel to come early.
I have no idea how long these next, I don't know how long Ms. Murphy's going to take. I don't know how long the next 2 witnesses are going to take.
Well,
I have no idea.
I guess the question is, Judge, if we end at 11:30 or 11:40, are you going to want to take a lunch, or do I need to have Dr. Broder here? Because he's in with patients right now, so I need to be able to tell him. We originally thought he was after lunch.
You mean with Ms. Murphy?
We have Ms. Murphy and then 2 other witnesses we plan to do before lunch. I just want to know if I'm safe to tell the doctors they can come after lunch so they don't cancel patients.
My habit would be if we finish with witnesses around 11:45, unless that very next witness was, both sides agreed it's going to be just 5 minutes, I would probably take a lunch break at that point.
Thank you. I asked it poorly. That's my question. I just want to be safe in releasing them so that, Your Honor, so we can keep moving. Or not releasing them, putting them after lunch. 1:30? Should I tell them 1:30?
It depends on when we finish this morning. I
Then
don't
I'll just
know.
tell them it's after lunch for now. Thank you, Judge.
Oh my God, stop being so whiny.
Are you ready to bring the jury back in?
Yes.
Defense? All right, let's bring Ms. Murphy in first.
So you remember the limiting instructions that Judge Cannoni gave when around surrounding text messages by Officer John O'Keefe, and that was a good limiting instruction. I don't remember exactly what it said, but she had a number of things that she went through in her instruction to the jury about whether, they have to believe whether the person who made the text message was actually the person who wrote the text message. And there were a list of things that she gave them to limit the instructions of the evidence in surrounding statements made by someone who's dead. So I don't know why they couldn't come to a consensus here or an agreement on what the limiting instruction should be. So they're just going to go on a question by question objection basis. Look at Sandy tuning in from Egypt. Thank you, Sandy. And hello to Egypt. We have a worldwide audience here, my friends. Somebody said, let me pull this up because this I found very interesting, that this attorney, are you talking about Stephanie Murphy, was on court TV with the cousin Tommy today? Really? That's interesting to me. Ice-T. There's no gag order, but that's bizarre that she would go on court
By the
TV
defense.
before
Back about the case. or doing
Testified.
research on the reason-
And as a result,
Beginning on August,
pretty much not speaking to. Actually, and
Resume your, this is things or legal topics we've heard anything about. Everybody says no. All right, you may resume your question.
And I believe as we left off, Ashley and Doug were not speaking to each other. Pretty much not speaking to each other.
right, beginning on August 16th, 2019, they were not speaking to each other.
Okay. And as a result of that, did you ultimately file anything on Doug's behalf?
I ultimately did, yes.
Okay. And what was that?
We filed a, gosh, let me think back. It was so many years ago now.
Well, that's so funny because you knew
series
every
of-
other sordid detail of their relationship, and now you can't remember what you filed right after they stopped talking to each other August 16th of 2019 when you probably reviewed your case file before you came into court today? So many years ago now.
Things, but one of the first things that we filed was an amended
Huh.
petition for divorce. And so it was actually a motion for leave to amend with the amended petition attached to it, which is the procedure.
So
She had never testified that he actually filed for a divorce. So when did he file for a divorce? Okay, I'm confused. Is this out of order?
That ultimately means it was not seeking divorce before, but now the petition is.
Yes, that's correct.
Okay.
And still the parenting plan with some additional allegations, but that's what the main first pleading was.
Okay. And at some point after this was filed, did you get information that there had been complaints filed against Doug Benefield?
Yes, I did. So that amended petition was filed, I think, November 6th or 5th of 2019. And then within a month, I would learn that there was a series of complaints filed with.
I'll sustain.
There's an objection. Sustained.
Ultimately, these complaints that were filed against Mr. Benefield, were they documented or filed in any way in your casework, in your cases?
Relevance.
I'll overrule.
So of course, we didn't attach them as exhibits to our next pleading, but we did file an amendment.
Sustained. That asked for a yes or a no.
Okay.
Maybe
Good.
the question for me.
Good. Don't you like how that judge
Those-
says that's a yes or a no? Answer yes or no. Judge Canoni never did that. She let the witnesses go on and on and on and on and on. Yeah, she does witnesses with Tommy. That's bizarre.
Complaints, did they make their way, the information at least, into your filings in your cases?
Yes,
Okay. At some point, did Ashley file an injunction request based on these allegations?
yes.
Okay. And around this time, was there a psychological evaluation ordered with Dr. Broder?
It was not ordered by the court. There was a psychological evaluation that was put into place through, I believe, the Child Protective Team.
Okay, she's an attorney. Okay, she's an attorney. She knows to stop talking when the defense attorney says objection. And she just steamrolled right through. Did you see that? That was intentional. And she should know better when there's an objection to stop talking. There's something she wanted to get out there, and I want to hear what it was.
Evaluation that was put into place through, I believe, the Child Protective Team.
She wanted to say child protective team. That's what she wanted to say.
So an evaluation was recommended.
I sustained it.
I requested instruction from the board to jurors to disregard the last answer.
Members of the jury, I have sustained an objection. When we had our initial instructions, the preliminary instructions on Monday morning, I want to remind you of one of those very important instructions. If an objection is made, you are not to guess or speculate as to why it was made. Likewise, you are not to guess or assume or speculate what the answer might have been had the objection not been sustained and the witness had been allowed to answer. So you're to disregard those last answers.
As part of this process
Hold
with,
on. Sufficient.
I'm sorry.
Thank you. Yes, sir.
Go ahead.
sorry. As part of the process of these cases in court, did Ashley and Doug Benefield, to your knowledge, see a Dr. Broder
Yes, they did.
for a psychological evaluation?
Yes.
Okay. Do you know when this petition for injunction filed by Ashley was set for a hearing?
I don't remember the date that it was initially set because she filed a motion to continue.
Objection,
Basis.
editorializing, not responsive to the question.
Ooh.
Go ahead.
It was continued several times after she filed a motion for mediation, and then eventually it was scheduled to occur, I believe it was September 30th of 2020.
Okay. So you said it was continued several times because of a mediation. So just what is a mediation and what is that? How does that play in?
Okay, so mediation is a settlement conference that takes place. It generally involves the parties as well as their attorneys, and then a neutral person who's You generally a certified family court mediator. And so what generally happens is a mediator goes back and forth between each side to try to work out an agreement. And in this case, it was ordered by Judge Moreland in response to Ms. Benefield's motion.
To do the mediation.
Correct.
Okay. And did you
That's often done in family court cases. They're required to go to mediation at some point to try and resolve it amicably. It's good practice. It doesn't always work, but it's something that's oftentimes ordered by the court, at least here in New York.
participate in the mediation?
I did, of course.
And also Doug and Ashley Benefield.
Yes.
And as a result of that, did some of the focus of the hearing coming up change?
In anticipation of the mediation, yes, the focus of the upcoming hearing on the 30th changed.
Okay. And in what way did that change?
Earlier in September, I think on the 17th, Doug and Ashley signed a joint motion to release the psychological evaluation reports in the divorce case, in the 2018 DR 2318 case. Because in that situation, the psychological evaluations had not been ordered by Judge Moreland. They were put into place through.
Again, she's
I'll sustain on the.
editorializing.
So they did a joint motion to release the psychological evaluation.
Yes.
And is that fairly typical? It's needed in this realm to get that result released to the parties.
Oh, of course.
Objection, relevance, it's what's taken place in this case.
Ooh.
A judge would not just release, is not
There's no
able.
question.
Oh, I'm sorry, Judge. I apologize.
A judge doesn't release.
I'm sorry, you didn't know, you're an attorney. Do you not cross-examine people or direct examine people for a living? You didn't know there was no question on the table and you just started giving a narrative answer? Meredith says, I haven't been this excited for cross-examination since Alan Jackson and Jen McCabe. Wow. Taking that back to just see how she just started talking with no question on the table. So they had jointly agreed, apparently, according to this attorney, to release the results of the psych evals. And that's interesting to me because the prosecution said in their opening statement that the reason that Ashley killed Doug, her motivation for killing Doug, was not self-defense. It was because these psych evaluation reports were going to be released. But if she agreed to release them, there goes their motive, right? I'm confused. I have questions.
To release the psychological evaluation.
Yes.
And is that fairly typical? It's needed in this realm to get that result released to the parties.
Oh, of course.
Objection, relevance, it's what's taken place in this case.
Ooh.
A judge would not just release, is not
There's no
able.
question.
Oh, I'm sorry. Judge.
See?
I apologize.
A judge doesn't release
Judge
that
doesn't stay.
report unless.
The judge orders that it
Oh,
can be.
talk about
released.
leading. Talk about leading. Oh my gosh. I'm so glad you guys are here with me because if you weren't and I didn't have this channel, I'd just be watching this by myself at home, throwing stuff at my television. Or in my car yelling to avoid objection, objection. Talk about leading.
Is not
There's no
able.
question.
Oh, I'm sorry, Judge. I apologize.
A judge doesn't release that report unless.
The judge orders that it can be released.
Okay. And Doug and Ashley did a joint motion for that to happen.
They did.
And to your knowledge, what was their path forward from that point?
The path that went into place was they were reconciling and moving to
Object,
Maryland.
Speculation as to what the path forward was.
Ooh.
Yeah, that's an opinion.
So when we were leading up to the week that he was killed, it was agreed upon that they were going to result in an impasse of the mediation because they were reconciling. And then the hearing on the 30th, the week after, was only going to be to release a psychological evaluation report.
Okay.
And they were going to pursue the move to Maryland.
Okay. So ultimately, the only thing that was supposed to happen at this hearing on September 30th was the release of the psychological event.
That was it.
That was it. Okay.
But if she agreed to have them
And do you
released,
recall what day of the week that was?
how is that a
September-
motive to kill him? I'm the prosecution's case is sort of escaping me right now. If that's their motive and she consented to their release and she feared for her life, that's the defense, and stood her ground and thought he was going to possibly seriously harm her or kill her in that moment. And she went and found a gun, told him to get away. He wouldn't. He came at her. She shot him. Anybody else having trouble following this case, or at least their theory of the case? Let me know in the comments, in the chat.
September 30th.
I believe it was Wednesday. So the mediation was a Thursday prior to the killing. And then the hearing was supposed to be Wednesday, the 30th.
Okay.
She can't say killing enough times.
And what day was Doug killed?
Sunday night.
And that would be the 27th.
Yes.
And who was the judge going to be at this hearing on the 30th?
It was still Diana Moreland. She was still the judge on the case.
And at all times that you dealt with Doug, did he ever seem to you overly angry or aggressive about things?
No, I thought Doug was
Objection.
never angry. He was very mellow and matter of fact. That it was a point of contention between us, actually.
Okay.
He was very mellow and matter of fact. Any survivors in the chat want to talk about the Jekyll and Hyde effect? And the charisma of abusers, and how oftentimes people on the outside think that they are the nicest, most charismatic men on the planet, and women. And yet nobody knows what goes on behind closed doors. But yes, he punched the dog unconscious and he threw the cat against the wall, shot a gun into the ceiling. We'll hear more about that stuff. But what did she say? He was the kindest, very mellow and matter of fact. It was a problem between them that he was so mellow and matter of fact. And why was it a problem for you? Did he ever seem angry or aggressive? No, not to you.
Overly angry or aggressive about things?
No, I thought Doug was never angry. He was very mellow and matter
Never.
of fact. That it was a point of contention between us, actually.
Point of contention. Why are you having a point of
I've never-
contention with your client? That sounds like a personal relationship. Sounds like a point of contention. You have a point of contention between us? It's your client, ma'am. That's so weird.
Questions, thank you.
Thank you.
Cross.
Yes. Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
We've met on a few occasions, have we not?
Yes, we have.
And we meet again this morning.
It's lovely to see you.
So your specialty is family court,
Family law, yes.
and you've been practicing family law, I think you've told us 23 years. You have your own firm, you and your husband.
Yes.
And in that capacity in family law, correct me if I'm wrong, but when you litigate matters in family court, excuse me, there are rules and procedure that apply to family court, are there not?
In all courts, and including family court, yes.
Okay, such as the rules of evidence,
Yes.
the rules of procedure, family court procedure,
Yes.
and ethical obligations as well.
That's correct.
Those always govern your behavior with respect to the tribunal, the court, correct?
All of our behavior, yes, that's correct.
Are you familiar with Florida Bar Rules of Professional Conduct?
Relevant.
Oh boy, here we go. Crossing boundaries, attorney.
I'll overrule.
Yeah.
I don't know where this is going, so I'll overrule for a
Oh, I
moment.
can't wait to see where this is
I'm-
going.
Are you
I'm familiar.
Yeah, Rule 4-3.3, candor toward the tribunal.
I'm familiar with that rule.
All right. You're familiar with that rule's obligation of a duty to disclose false evidence.
I don't have the rule in front of me, so if you want me to read and see if that's exactly in the rule, I can certainly take a look at it. I'm generally familiar with the obligation to provide candor to the court.
Yes, and to disclose if evidence is inaccurate. I think
Yes,
we can
exactly.
agree on that,
Of
correct?
course.
That would include, would it not, a failure to correct a materially false statement of fact?
Yes, I'm aware that that exists, but I don't see how that could apply to my case with Doug.
All right.
Well, he's going to
let's see.
show you, counselor.
I want to ask you about a sequence of events now relating to the litigation that you mentioned to us between Doug Benefield and Ashley Benefield.
Was this the injunction you're referring to or the divorce case?
I'll be very specific in my questions, if you'll be patient for a moment.
Of course.
Oh, I love him.
Ashley Benefield files her domestic violence petition on April 23rd of 2018. Is that correct?
I believe that date is correct, yes.
Just so there's no mistake. She then, correct me if I'm wrong, because you seem to have the dates mastered. Ms. Benefield then files a petition for divorce and temporary TPR on May 31st of 2018.
I don't remember the date that she filed those, but she filed, those would be, I think, separate things. And so in response to the petition for parenting plan unconnected with divorce that I filed on Doug's behalf, she filed an answer and a counter petition seeking divorce.
So your answer for purposes of my question was you don't recall the date.
Yes, that's correct.
Okay.
And it wasn't that she
May I
just.
approach the witness?
Yes.
Stop
See if this
narrating,
refreshes
counselor.
your recollection as to the date.
I need to get my reading glasses, Mr. Tate.
Everyone hit the like button because this is going to be good and you might want to go get some popcorn. So here it is. Ashley filed for divorce first.
While you're looking at it, when I refer to the initials TPR, what does that stand for?
Termination of parental rights.
Okay.
Yes, thank you for the reminder. You're right. This is the 31st of May. And she did file a separate case. I had forgotten that.
Well, the
Oh.
question pending was, does that refresh your recollection as to the date?
As to the date, yes. The
Yes.
contents, no.
Was I correct in my statement to you that the date was May 31st, 2018?
Yes.
Now, would you take a look, if you need to refresh your recollection, as to count 2, specifically paragraph 5?
Ooh, this is going to get good.
Ms. Benefield makes some allegations there, does she not?
She does.
All right.
Read 'em.
On June 19th of 18, you file Mr. Benefield's answer.
I don't remember that.
Oh, good. Show her. Okay, Jennifer McCabe, we're going to show it to
May I
you.
approach?
Yes.
You want to see it?
Let's see if this refreshes your recollection.
No spoilers if you're ahead on another stream or 2 or 3. Hit the like button for the algorithm, please.
Is the date June 19th, 2018?
Yes, that's correct.
All right. And that's your answer, is it not?
This is Doug's answer that I drafted and
Okay.
filed on his behalf.
That
Yes.
you drafted and filed on his
Yes.
behalf.
Correct.
And it
Everything was we before on cross-examination. Everything was we. And now, oh no, this is Doug's answer that I filed on his behalf. Okay. Now she's trying to separate herself from Doug. Watch, this is very interesting.
in response to paragraph 5 of Ms. Benefield's petition, you deny it, do you not?
Objection relevance, Judge?
Oh,
I
he'll
think
get
I'll
there.
overrule on those
Yeah,
grounds.
thank you, Judge. Ms. Murphy, my question was, if you would look at paragraph 5, do you enter a denial?
I'm sorry. It's number 5 is 7 pages long. So I was just checking to see if that was correct.
Well,
Yes,
your answer.
we denied these allegations that
Okay.
he committed those acts during pregnancy.
Now, as part of that action, your client, Doug Benefield, submits to a deposition 27 days later on July 17th, 2018, does he not?
I don't remember that exact date, but he did submit to a deposition around that time frame.
Okay, and in that deposition,
Objection,
while,
pretrial motion.
Sustained.
Your Honor, she opened the door.
She did. She opened the
She's
door.
already talked about,
Maybe
Would you
approach,
like to
please.
approach?
yes.
Yes, she did open the door. He gave a deposition. She denied everything. And she even said he denied that 7-page long paragraph as to the things that he did when she was pregnant. And she opened the door to it. And now he must have given testimony during the deposition where he admitted to some of those things. And it would be her job as the attorney to correct those pleadings and enter some admissions as to those paragraphs. For those of you who don't know, when you're served with a complaint, there are numbered paragraphs on the complaint. And then when you submit your answer, your attorney submits the answer, they have to go through the complaint and admit or deny each paragraph separately, or you can admit certain portions of the allegations in a paragraph, or you can deny knowledge and information to form a belief about the allegations in a paragraph. So she denied that entire paragraph. And then there must have been something that he said at the deposition that were admissions, and under the rules of ethics that Mr. Taylor so eloquently pointed out at the beginning of his questioning, she may have had the obligation to correct those pleadings once those admissions were made. So let's see where this goes. I think she opened the door. For those of you asking why Ashley's wearing headphones, it's so that she can hear what's going on at sidebar without getting up and going up there every time. Getting spicy.
Jury, here's what we're gonna do.
Oh man, they sending him out again?
All right, members of the jury, here's what we're gonna do. I'm gonna go ahead and let you go to an early lunch. It's about 11:20 right now. So the good news is you get to beat the crowds wherever you decide to go. If you could be back downstairs in that jury assembly room where you start each morning at 12:30. And we'll look forward to getting you back up here as soon as we can after that. Please remember, if you do go out somewhere and have lunch, if you go in a group, that's just fine. You can absolutely go in your groups, but do not discuss the case at all amongst yourselves or anything about the case. Don't talk about the case with anybody outside of the jury. And please don't do any legal research on the people.
You were a little bit behind.
The juror in this case. An early lunch break. I want to remind you that the rule of sequestration has been invoked, so you're not to discuss your testimony or the questions asked of you with this, or talk about what their testimony was, or will. You can also be here. All right, we'll see you guys back here at 12:30.
I wonder if they're going to argue. Are they going to argue anything? No, that's it. Just come back at 12:30. Boo! I want to know. You can't leave us. You can't leave us off with a cliffhanger like that, Judge. We need to know. We need to know. Let's go to the chat for questions. That was just getting really good. Well, it gives everyone the time to go make some popcorn anyway. Lori Life 360 for the win. Thanks for gifting 5 memberships. You're so kind and generous as always to this channel. And to those of you who received those randomly gifted memberships, welcome. Wow, Lisa, 5 months already. Love you. Love you back, Lisa. Thank you so much for being a member for 5 months. Karen's a member for a month. Thank you, Lori Life 360, who gave Karen a gifted membership. Welcome, welcome, welcome. Michelle Fannin, thanks for the 5. Says, why discuss it with anyone? They're not going to believe you anyway, and they're probably going to blame you. Thanks for chiming in. The Aruba chicks. Lizzie says, definitely more than a professional relationship. Regarding that last witness, Stephanie Murphy, and her late client, Doug Benefield. Mel Klump, thanks so much for the 5. A good parent would do anything to help with the introduction to keep their kid comfortable. Right. This was the first time that the baby was meeting Doug. This attorney told you that she thought it was really odd that they were going to go together. She was almost offended by it. It was really weird. If you're tuning in late, rewind and watch the testimony of Stephanie Murphy, who was Doug Benefield's family court attorney. I agree with you, Mel. Thanks for the 5. Wendy, darling. Thank you, Wendy, darling, for coming in and for gifting a membership. I appreciate you so much. M. Thompson, thanks for the 10. I can't explain this kind of relationship to anyone. I've been in it for 22 years and just started to talk about and understand it and work to get it out. It's not simple or easy. I'm so sorry that you're going through that. Mr. or Ms. Thompson, for 22 years. And thoughts and prayers go out to you and strength. And there are so many warriors in this chat. And thank you for the super chat. And welcome to Patty's Home and to Lori Fossa for joining and for being new members. And Sarah Gray, who's been with us for 9 months. Thanks for watching this trial with all of us. It is my pleasure to be here with you. As always, Susan Costello, thank you so much for the 20. You're so very kind and generous and such a great part of this community. Ben George gifted 20 memberships. Ben, thank you so much. We love our male viewers here and you guys are amazing. Thank you so much for gifting 20 memberships. That is really, really kind and generous of you. And I highlighted this to said from James McCleary, who said, just to let you know, I'm a man, I'm a welder, and I guess you're typical man, and I absolutely love this channel. Thank you. Thank you. We love our male viewers here because they are, I don't know, a different brand of guy, maybe. You know, men who aren't afraid of strong women, men who believe women, men who are actually kind. There are a lot of you out there. I know that. I'm not generalizing, but if you've been in any other chats, it's mostly the women that are nasty, which is so crazy to me. Thank you, Ms. So to the men that can hang with us, we love you guys. You are a very important part of this community. Ms. Mojo Horizon, thanks for being a member for 7 months. We appreciate you. And Hannibal TLC for being a member for a month. Melanie, your trauma-informed approach to hosting streams is absolutely refreshing. Thank you. You're welcome. I don't understand why everyone can't do it. I'm so surprised when I go watch what's going on other channels. I'm really surprised by it. Leanne, thank you. My partner Jason is watching with us for the first time today. If you could say, hi, Jason. Hi, Jason. I hope the defense wipes the smile off her face. Thank you, Leanne. And Jason. Jason, thanks for watching. You're welcome to join all the cool guys in this chat. Tara wanted to know if the guy sitting at the little table behind Ashley is her Craig Bates AV. Yes, it is. They had to make a motion pre-trial to allow him to even have that little table, which Judge White referred to as, you mean it's just going to be like a TV tray table? And that's what we called it in the Karen Reed case. And so it was so funny when the judge came out with that TV tray table. Those of you who remember. The stand your ground law in Florida, lady in Boston wants to know what that is. It's a form of self-defense in Florida. I'm going to pull up the exact wording for you. Shoot first, no duty to retreat is what it's sometimes called. Florida's stand your ground law, allows a person to use force, including deadly force, if they are attacked in a place they are legally allowed to be, and reasonably believe it is necessary to prevent death or great bodily harm. This includes preventing the commission of a forcible felony, such as burglary of an unoccupied vehicle, However, the law does not apply if the person using the force is committing a crime, such as trespassing or breaking and entering. And that is the law in Florida. You do not have a duty to retreat as you do in many other states. You have a duty to retreat. In Florida, you do not. A lot of people are confused and think that stand your ground was dismissed. It was not. There was a motion to dismiss the case based on stand your ground immunity that was heard by the court. Ashley did not testify at the 2-day hearing in that case, and the judge denied it because he didn't think there was enough evidence. That doesn't mean they're not allowed to use it in this case. It just means that the motion to dismiss wasn't granted. And as you know, if you follow a lot of trials, it often is not granted. So that was no surprise. Hi, Melissa. Thanks for coming in with the 5. I'm eating my free Karen Reed popcorn. It's as delicious as an FBI investigation, but not quite as sweet as the arrests that will be made. Yes, for those of you who don't know, in the Karen Reed matter, Massachusetts State Police Internal Investigations has opened up investigations into Brian Tully and Buchanan and Fanning, who are all part of the Karen Reed or John O'Keefe murder investigation. And it has been reported, I think, that Fanning's internal affairs investigation has ended as unfounded. I'm not quite sure about that, but that's the word on the street. Laura says, Ms. Murphy, abusers can behave in front of lawyers. Thanks, Laura, for tuning in. I'm curious to see that court TV with the cousin this morning. Do you guys know where to find that? I'm going to look and see if I can find that quickly. We can take a look at it. That Tommy and Stephanie Murphy were on court TV this morning. I'll look on their website real quick. Or is it on YouTube? Sometimes they don't post them right away on their website. You have to see it live. If anybody knows where to find it, let me know. Let me know and we'll come back for it. We'll come back for it later. I'm going to set up the afternoon stream and then we're going to teleport on over there in just a minute or two. So if you have any further questions before we take a little bit of a break, please let me know. Tommy is with an IE, not a Y, correct. Pennsylvania is also a stand your ground state. Castle Doctrine as well. Colorado, back when I lived there and I was going to law school and college in Colorado, it was called the Make My Day law. If someone came on your property, you were allowed to shoot first and ask questions later. Looked on the Court TV app. I didn't see it on the Court TV app either. Oh, thanks, Jenny. Somebody has the iPhone link for memberships. I also put the link in the video description below this video. So if you would like to join, just go down into the video description and you can likely find it right there. I'm also going to point out to you what Marcy's law is because a lot of people had questions about why Eva Benefield was allowed to sit in the courtroom. And it is under the Victims' Rights Law in Florida, known as Marcy's Law, Marsy. And as the family of a crime victim, you have certain rights. The right to due process and to be treated with dignity, fairness, and respect. The right to be free from intimidation, harassment, and abuse. The right to be reasonably protected from the accused and any person acting on behalf of the accused. And part of that also involves being allowed to be in the courtroom, even if you are still under subpoena. And we also saw that in the Karen Reed case when members of the families were both allowed to be in the courtroom on both sides after they testified, even if they were on the other side's witness list. So we've seen it. Ben says, thanks for the 10, Ben. I have 3 older sisters, so maybe that's why I never considered gender when subscribing. I don't understand what it has to do with facts and opinions. It confuses me. I don't know either. Well, here's the thing. A lot of men are not that interested in true crime. And I don't know. So I don't know the answer either. I just do know that when I started this channel, I had 92%, I think, women following me and 8% men. And then with the Karen Reed case, the numbers have grown, and I think we're up to 25% male viewers. So we love that you're here. I think it's more of like a show of appreciation than anything else. So thank you for being here and for enjoying the commentary and for hanging out with us and for giving your perspective and for really supporting women, because it's really important to us. All right, let me set up this teleportation and then let's all go over there and let me know that you made it safely. So once I set up this redirect, you will be transported automatically to the afternoon stream. And we will reconvene there at 12:30. Have a lunch break. My mods need a little break too. I think everyone needs a breather from this. I'm going to try and find that video of cousin Tommy and Stephanie Murphy from this morning, and hopefully we can find that. We can all take care of a couple of quick things that we need to do, and I will see you back here at 12:30. Thanks, mods. Everyone hit the like button on your way out, then hit it on your way in to the other stream because it doesn't carry over. So thanks, you guys. Be cool, be kind, be classy until we meet again in less than an hour. See ya over there, everyone. Safe travels.